Mission. Serial number 44, my lords. I appear for the complainant. My colleague, my lords, is not present today due to his ill health. I request my lords to have it on another day, any convenient day, my lords.
5th February.
Oblige, ma.
My lords, serial number 52, my lord, I appear for the petitioner. We have engaged a senior counsel and we request for adjournment, my lord.
52.
52, my lord.
The request of learned Miss
M. Gauri Padmaja.
send over to the state. 11th February. 11th February.
Please, my lord.
Your Lordship, serial number 9, I appear for the appellant. I request for some time, my lord.
9.
Yes, my lord. I've informed the caveator respondent as well.
The delay of 14 days. Will issue notice.
No, my lord. The respondent is also unwell. He asked me to pray for some time. All respondents are represented. Caveator respondent, my lord.
All the respondents are represented.
All are represented and they have filed objections also to my IE for seeking condemnation of delay, etc.
14 days, what is the delay? What is the objection? All right. And if objections are filed, then 4th of February.
Very well.
Any mention through VC, sir? This contempt matters, seal number 1 to Shiva Reddy KN. Seal number 1 to Shiva Reddy. This seal number 2 to Vasant Kumar HT. This number 3 to Shashidhar S. Karamadi.
Okay, to the complainant petition. You paid the consideration. You paid the balance consideration. Paid. Where you ever spent it? The contempt. Ready with the balance.
I paid all the consideration, balance
Notice,
consideration.
notice returnable. 10th February.
Much.
This is number 4 to Ramesh KR. Number 4. So number 5. TPK.
For the accused in this case, my lords.
Where is the last? Now things are over or not?
Lords,
What is the state of things?
we have complied with the orders, my lords. There are two aspects.
My lords, may please peruse the compliance certificate for a moment. Instead of simply averring compliance, hundreds of allegations are made against the complainant and me also, insinuating against me also. which is why I take strong objection. The simple question that is for consideration before my lords is whether the transfer that they have done
Is it compliant? Where is the compliant?
they have filed compliance certificate on 6th, my lord.
This itself, this last order itself was in fact conclusion of the.
My lords, I'm filing a memo which has,
So you filed some memo before the trial.
no, that was over, my lord. That has been stayed by this honorable court. We had sought for 2 commissioners to be appointed. And your lordships clearly suggested, directed me.
Comply with the directions of the court.
Yes, that has been done.
So it is done or not?
It is done. My lord, I would like to make a submission, excuse me, this memo. So this is a memo that I'm filing with an email from the commissioner, wherein I had asked him specifically to list out what we have done and what was supposed to have been done. My lord, kindly look at, I didn't have the time to put the page numbers. After the memo, this talks about interim status in page 3. At page 3.
Just the direction, recollect the direction, original direction.
Original directions was,
25/11/2024.
No, direction original,
that's what, 25/11. On 25/11 of this honorable court,
page.
that is not a part of my memo, lord. Okay, yes.
Page of, page in the. Just I also,
My lord, at page 67 of the complaint,
7.
yes. Number 3 in orders. Yes. Page 67.
Hereby restrained from selling the source.
No, before that. Number 3, it says, I number 3 filed by the plaintiff under order 39 rule 1 and 2, CPC is hereby allowed.
The direction.
Of the honorable high court.
Page number 32 of the complaint. Page number 32 of the complaint.
This doesn't have any directions in this.
30.
Please.
That is the appointment of commissioner. Where is the original direction?
My lord,
That
page
is a
number
67, my lord. 60,
page number 32, point number 2 is the direction.
just to comply.
Comply,
That's it.
obey the directions 13/12/2022.
Directions is on 67.
Where are those directions? Page
67. Here it says, I number 3 filed by the plaintiff under order 39 rule 1 and 2 is hereby allowed.
plaintiff.
She is the plaintiff.
So this is in presence of the court only.
Yes, ma'am. No, this is not for, this is on the interim application that they had filed for transfer of website. And I had filed an application for securing the source code, which is mine, is what I've contended. Subsequently, after this order was passed, I filed an application for appointment of commissioner. That came to be allowed on 27/3. Against that order, the plaintiff challenged in writ petition 10952, wherein the orders passed for appointing the commissioner was upheld. And one of the directions was that we have to comply with the order. Against that, they have filed this contempt petition. You can see the appointment of commissioner at page 108.
So what remains now?
My lord, I'm filing my reply to.
No, these things have been, these directions are complied with in the presence of court commissioner. only.
Yes, my lord. All of them have, there are two, I would like to make one submission, my lord. On 25/11/2000, on 17th in November, a submission was made by the complainant stating that she will make the payment under protest. It was categorically made. And during the request that we were asking for, when the transfer was happening, we asked the plaintiff to make the payment. It was categorically denied. I have attached the response made by the plaintiff's counsel there, where she says there is no clear directive from the court. And secondly, that I have filed an application for clarification before the court. And once the clarification is, once the court clarifies, then she will pay. That was not the understanding, Lord. Lord, another thing is, there is no direction by this honorable court, by any other court, for transfer of source code. On 17th, your lordship.
This must have been done, entire process is reflected in your memo
It is there.
overview.
It is there, my lord.
Use of the source code.
Yes, yes, my lord. I mentioned this also. They, after making a statement that they will pay, they're reneging from the promise that they made before the honorable court. And now they're asking for a direction. My lord, if your lordship may kindly see, in IA number 3, when the order was passed, it clearly says that the money should be paid to the defendants. That is to me. Now they are not doing it. Now they are asking, waiting for a court's directive.
Paid or not?
They have not paid.
It is part of the direction,
There is no directions, but your lordships have
Not
recorded
part
it.
of the direction.
recorded,
Yes.
not
Well,
paid.
My
Not
lords,
paid.
which is why I'm filing
What
this.
is the amount to be paid?
My lord, about 2,92,000 rupees. They should have paid.
That is the amount towards what?
That is the amount of the costs incurred for us for keeping their website on my website. It is a part of the counterclaim before trial court.
My lord, please have my reply. I have produced documents.
After
to-
making a statement before this honorable court. I'll copy, please. Thank you.
Now the directions that has to be complied with by both the parties
Yes,
are as per the trial court order, which is produced at page number 67 and
yes,
68.
Lords.
That's
Yes,
all,
Lords.
right?
Yes, Lords.
Hmm?
We have done our part.
You have done your part.
They have not done
Lords,
their part.
if I may, my lords, at page number 67, it says plaintiff has to pay the admitted amount. We have long back filed a memo of compliance before the trial court, which has been allowed already. So our contention was that we do not even owe the amount. However, in the interest of getting the website back, if this honorable court directs, I will make the payment. I had made that submission. In fact, I'm still willing to do that. The defendant himself has filed a memo of clarification of this order.
Okay, one by one. Now, first come to page number 67.
Please.
They have not tampered with your website now after the order.
That is the testing that is still pending, which is why I'm requesting them to give time till Jan 15 so that we can test. They are telling testing is not part of directions, and so they have complied.
My lords.
That is one of my first objection that I've raised in my. All I'm saying, I in fact told also, I will not press for any orders on this date. Give us time till 15. Let us at least check the functionality of the website.
My lords,
All
one submission here.
done.
One submission. My lords, the website was transferred to them on 3rd of January. They were unable to go into the website until 5th because their competencies were at stake. In fact, I was the one, I offered them on 4th morning, call me if you have any problems. They did not call. On 5th, when the commissioner got onto a call with us, that is when we directed them, we showed them how to, they didn't even know how to put the proper URL. They didn't even know how to change the password. That is the competency of these people.
Milords,
My lords,
such
this is,
kind of submissions
my lords,
being made
my lord-
for this honorable court
my lord-
without the commissioner, and when the commissioner has
every single thing is recorded, my lord. We have recorded information of every single second that was done by the commission.
So now it is hosted back on their server, right?
It is there on their server, my lords.
It is
it is
hosted back on
hosted back, the only thing that is pending is testing of the functionality of the website. To assess the tampering of the website, that's all. For which all I'm asking is time till January 15th to test it.
My lord, I asked directly the
We will test it, my lord. My lord, the plaintiff is a senior citizen who came back, in fact, to India to do the compliance, my lord. And then because she has had to return to Geneva, she left and she's asking for 1 week's time to test
I have no
it.
objections, my lord. Let them test. But
That is the only thing left.
That's the
I'm
only
okay.
thing.
My lord, I have no issues with it. My lord, the money part,
With respect to
money
payment,
part, they have made a
let me make
submission.
my submission. Let me make my submission, my lord. My lord, we have our contention, even on the first day of argument before this honorable court, was that we have already paid. Our memo of compliance is allowed by the trial court. They have filed a memo of clarification after filing of this contempt petition. All I'm saying is, let that memo of clarification be heard by the trial court. I'll deposit the money in the trial court. If he wins, let
But
him
one submission.
clarify. I will take.
My lord, one submission. I
What?
filed a memo of.
My lords, the memo
What-
of
madam, one
clarification.
minute.
is
I would like to
at-
clarify something.
by the time, my lord. Please,
My lord.
memo of clarification
Memo-
filed by the
my lord,
defendant.
Memo of
After
clarification.
filing of
One second, ma'am.
petition.
One second. Memo of clarifications was filed before a commitment before the honorable court was made that she will pay under protest. My lord, when she did not pay, I filed an application under Order 39 Rule 2A. That was filed in 2023. It is still pending. They keep saying that they have paid. We have always said they have not paid. Which page, ma'am?
Page number 15 of my reply, my lord, is the memo of clarification filed by the defendant.
My lord, after making a submission before the honorable court, wherein she says that I'll pay under protest. And my lord, another thing was made.
Okay, what is the admitted liability?
My lord, admitted liability, they say they have paid. The other
We
parties.
haven't
amounts
challenged my
claim.
memo of,
One minute, ma'am.
my memo is also not
My lord, I'm
challenged.
not
It's
allowed to
at
speak.
finality.
The respondent is making his submissions. Let him make his submission.
Please.
My lord, I need to go to the background of this case. I'll just take 2 minutes, my lord. When the plaintiff filed this suit, she says that she had paid the invoices that were paid to us even before the filing of the suit. I am claiming for the amounts which are due to me for keeping our website after filing the suit and 2 or 3 months before filing the suit. The payment was made in the month of June, July 2021. My payment request
What is the admitted liability per month?
to around $200, my lord.
Per month admitted liability is
Yes,
$200.
$200 for keeping the website up.
Now, where is it stated so? $200.
We have filed it in the trial court, not.
Do you agree that $200 is the admitted liability per month, recurring expenses?
Milord, $200 is the amount per month per server. So what the defendant is a developer. So it is not that it's only my website that he has kept in his server paying $200. Moreover, I myself have been paying $200 every month for my server from which he took my website.
No, my lord. That's not the case, my lord.
Why am I paying I'm paying for my server. He
My
took it from
submission is,
my server to his server and now is claiming that I have to pay.
that is before the trial court, my lord.
No, counsel, see, we are dealing with contempt over here.
Yes, my lord. We have complied with our.
The trial court order does not determine what is the admitted liability.
Yes, my lord.
It merely
Please.
says admitted liability.
Please.
Yes, my lord. It also says or dues claimed by the defendants.
The trial court order, it says that.
At 67, it says admitted liability or dues claimed by the defendants. Two parts of it.
It does not define what is admitted liability.
Which,
My lord,
which is
it
why
defines.
I
My lord,
filed a
my lord,
memo
there
of
is a-
clarification. All I'm saying is,
My lord-
let that be decided and money will go to whoever.
My lord.
But website is hosted back
Yes, my lord. It is done.
main part.
No, but the point, he also have to keep it on his.
Well,
The
sir, but
website
clarification.
will be alive on your
Yes, my lord.
thing as well as yours.
No, no, no. Only on
on
that.
my
We don't want any, it's on that. My lord, this admitted amount and invoices dues are part of my counterclaim, which is before the trial court. That is what the trial court is saying here.
Nowhere in the order it records what is the admitted. Nowhere in
A
the order.
submission was made before your lordships.
My lords, if I may be given 2 minutes to summarize the aspect, my lord, before this contempt, under the jurisdiction of this contempt court.
That has to be determined by the trial court. See, in contempt, this petition, we cannot determine what is the admitted liability.
Yes, my lord.
Exactly.
I
That
agree.
has to be determined in the trial.
Precisely why I am making a submission. In fact, I've sent an email also. Let their memo of clarification be
So-
determined by the trial court. I will deposit the money before the trial.
But that is to be done by the trial.
And to be paid to defendants, my lord. And to pay to defendants, not to trial court. That is what it says.
To be determined with trial.
That is being determined by trial court. It is pending.
Yes.
My lord, the matter is stayed right now by this honorable court. The stay may kindly be lifted. So that the matter is posted for 21st of this month. We'll proceed there. But my lord, my humble submission is, if we go directly,
Then let the plaintiff test.
Yes.
let her test. I have no issues, my lord. I have no issues. My lord, my submission is plaintiff and defendants in this case there is no trust between the two parties. So now what is happening is the plaintiff is testing for the past 6-7 days without giving us testing scenarios. We don't know what they are doing, how they are doing. And there is a chance that they may come out and say anything. The commissioner has categorically said, if you find any problem, you need to substantiate it. And we are not required, according to the commissioner, to fix small bugs.
Agreed. We
My lord,
ourselves have agreed.
Yes, my lord, I agree. The problem here is, my lord, let the trial court determine, but the money has to be paid to us, my lord.
He needs to certify. He needs to certify.
Directing, if your lordships may kindly direct the trial court to determine the amount and pay the money to the defendants, I'm okay. my lord.
That's all I'm also asking.
No,
my
you
lord.
said you'll deposit in the court. There's a difference.
Fine. I thought I'll upfront deposit before the court, let the trial court decide. Let the trial court decide and then I'll
That is
pay
not
the
what was said in the
defendant.
email, my lord. See, it was said categorically, they will not
Can
pay.
be withdrawn by the defendant
ma'am.
if they win.
No.
My email is there.
My lord,
No, simply
lord,
no, yes.
there is absolutely no direction for transfer of source code. I have done this after making a submission to this honorable court, and no directions was
No,
passed,
let
even on
the
17/12.
defendant Not do it as a favor, my lord. We are in contempt court every time.
Don't cross talk both of you. Submit one after the other. You want time till 15th, right?
That's all. That's all.
Commissioner was appointed.
Who was appointed?
My lord,
Who was
Court Commissioner is Sridhar Partha Sarathi.
appointed?
No, my lord, he's a court commissioner, he's a technical person. He's an AWS certified technical person.
Is a court employee?
Sorry, ma'am.
Court employee?
No, my lord.
No, my
No.
Outside?
Outside. And my lord, we are paying 10,000 rupees per hour. We already paid 2 lakh rupees to him in only commission fees. It is becoming exorbitantly expensive for us to maintain this.
50%.
My lord, there is
What
more.
makes
I don't want to
statements-
make allegations here. Your lordship may kindly see my compliance memo. How they have been trying to manipulate the commissioner and only giving their set of documents and not informing me, not informing trial court. before she came on record. I'm not blaming you. Before she came on record by previous advisors. The commissioner was appointed by the court, and they were the ones who chose this commissioner and gave plaint and every single document belonging to the plaintiff and not shared any of our documents. And it was not brought to our notice or the court's notice. And now we have complete faith in commissioner because he's conducted his commission very fairly.
My lord,
Fine, then let them do the testing.
Yes.
Let the commissioner submit his report. Then this issue can be resolved.
Yes, my lord. Meanwhile, my lord, that direction may be issued to the trial court to determine the amount and direct the plaintiff.
We may do in the next,
Next date of hearing, my lords.
today we are only permitting them to test.
Lord, kindly record our submission that we have complied with the court's orders. Our part, my lord, if you may kindly see the commissioner's interim report at page 3.
Contempt proceedings come up for consideration in light of the orders passed earlier, from the last of which was ordered at 17/12/20.
My lord, my humble submission.
Today, it transpired in course of the submissions by both the sides that as required under the directions of learned single judge, read with the directions of learned that is 53rd additional
Yes.
18th additional CPCL of Bangalore, comma,
18.
the plaintiff's website
Yes.
has been hosted back
Yes.
by the defendants in compliance of the directions passed by the learned additional judge, which is done
Yes. Commissioner's report says so. He's marked it here.
in the presence of the commissioner
Yes, ma'am.
who was appointed
Yes, ma'am.
by the court. In the directions issued by learned addition city civil judge, one of the hosting back of the website was on the condition that the plaintiff shall pay the admitted amount due to the defendants for the respective invoices or dues claimed by the defendant. Full stop. The amount, the issue as to what amount is admitted is in the realm of dispute.
And what amount is
No,
due,
certain-
not admitted, my lords?
And there is
Amounts
no
due, my
certain
lords.
admitted amount, full stop. This issue may be considered and addressed in the subsequent hearing. Full stop. Today, learned advocate Miss So-and-so Spriti,
please.
so-and-so, Spriti fixed time by submitting that the plaintiff petition whose website is hosted back, in whose favor the website is hosted back, wants to testify
Yes,
the functioning
please.
of the website. Full stop. Learned advocate, Mr. So-and-so, the respondent has no objection. If the plaintiff is permitted to test the website which is already hosted back, according to learned advocate respondent, the website is fully functional.
Yes.
Full stop. The plaintiff is permitted to test the functioning of the website. However, it shall be done in presence of the very commissioner who is appointed by the court, namely
Sridhar Parthasarathi.
Sridhar
Parthasarathi. Yes.
Parsar. Full stop. The said commissioner shall be arraigned as party respondent in the proceeding. Full stop. A direction shall be issued. The direction is issued to him to ensure to facilitate in the presence of the plaintiff as well as the respondent, petitioner respondent, the testing of the website. This exercise shall be undertaken before the next date of posting of the contempt petition, and the said commissioner shall submit report. The court.
Yes, to this court, my lords. Please.
Stand order. Can we dispose of?
Yes, my lord, one submission though. in IA number 3, it says amounts admitted or invoices claimed or dues claimed. That may be recorded.
Indicating that amount is not, as my brother is rightly saying, there is no admitted
No,
amount.
no, it says amounts
So we
dues
will
claimed.
Require you to go before the trial court and get.
No, my lord, my submission is, it's okay. We will go to the court. I'm saying in the order, if it is also mentioned or dues claimed, because then they will say admitted amount is something else, dues claimed is something else.
They're not going in.
No, not, I'm talking about the plaintiff.
Not force you to comply. with
I'm
it.
just asking
Since there
your
is-
lordships to just mention or dues claimed in the orders. I'm just requesting your lordships to just mention in the order invoices or admitted amounts or dues claimed. It is a part of the orders.
My lord,
In the orders passed by the trial court at 67, it says admitted amount due to defendants for the respective invoices or dues claimed by the defendants, it says.
For the respective invoices or dues claimed. by the
Yes,
defendant.
Much
That may
obliged.
be added.
Yes.
So same.
Yes,
same
ma'am.
language.
Yes.
my lords, one small submission. The compliance certificate that they have filed, instead of stating much about the compliance, a lot of things have been told against the plaintiff, my lord. Let them file a better compliance
My lord,
affidavit.
we are
Otherwise,
facing
I'll
issues,
be
my lord.
forced to.
My lord, we are facing issues from the plaintiff, my lord.
We'll weed out all unnecessary
Yes, ma'am.
in the next order.
Yes, ma'am.
Very well, my lord.
Much obliged.
See, in your own interest,
Please, my lord.
both of you, just go on with the things, just severe properly and go.
Yes, ma'am.
Severe your relationship, settle the things and go.
That we have done, my lord.
It has
We've already
been
done
tried
this.
multiple times, looks like, my lord.
It's already been done, my lord.
Website is code for
My lord, she is plaintiff is a journalist.
journal.
Yes.
Journalist,
She,
my
she
lord.
was,
She's
she
an,
was posting some articles and her images. That's it, not.
She's an authority in tunneling industry, my lord.
Yes, my lord.
And her website is fully about
ma'am.
about tunnels alone. And since the website, she claims that it is stolen by the
My
defendant.
lord,
she-
I take
she is not
objections to
ready
these statements. They are keeping on saying
claims-
stolen.
She claims.
No,
I'm not-
please don't
I'm
use the word stolen against us.
So she is
My lord,
not.
much obliged, my lord. Stand over next statement, lords, because this is not going to
How
end.
you function in,
No, my lords.
you are not able to function.
My lord, this is the problem, my lord. My lord, we were threatened with no ifs and buts by the plaintiff there, my lord, in the commission.
So when shall we keep 5th of February,
16th of
16th?
Yes,
of
my lord.
January.
January.
Or 16th of January.
Much.
So we said at 2:30. On that day, we propose to put an end.
Yes, ma'am.
Please, my lord, that time.
2:30 minutes.
2:30.
Much obliged.
Green bench matter, PAL matter, still number 6, Mr. Puneet C.
My lord, the petitioners, my lord, the respondent number 4, Tahsildar, by virtue of an order, please, my lord, annexure A, reserved 5 acres of land for the purpose of the government. Subsequently, there has been a mutation also affected, incorporating, my lord, reserving the land of 5 acres.
All right, but what is your interest? Who are you?
Please, my lord,
Who are you?
my lord, villages of the Gantkanali village, please, my lord.
Villagers are interested in such things.
My lord,
Get to one
only
side.
there is an order, my lord, annexure B, mutation.
Make a representative, decide.
My lord, representation is being made, my lord.
Then they will decide within 8 weeks. Dispose of.
Please.
The only prayer which comes for in this public interest petition is that in respect of land bearing survey number 40 situated at Vantana Halli village, Uttari Durga Hobli, Unigal Taluka of Tumkur district. From according to the petitioners who are the villagers. The mutation entry is required to be effected in the name of the government.
Name. Already there is a mutation. It has to be incorporated in the RTC.
RTC entry is to be effected in favor of the government. And that there is already a mutation. In this regard, it was submitted, in this regard, comment was submitted by learned advocate for the petition, Mr. So-and-so, that a representation is already pending before number 4. Dash the Tehsildar, Unagil Taluka, Tumkur district. Learned additional government advocate fairly submitted that representatives will be considered in accordance with the time limit which may be provided for by the order. In the aforesaid, without going into any other aspect of the merit of the subject matter, comma, the petition is disposed of by requiring the, where is your representation?
My lord, it's
Author
the
presentation. In particular, for hearing, to decide the representation of the petitioner, which is made to the assistant commissioner.
My lord, Tahsildar, respondent number 4.
Where is that representation?
My lord, annexure,
my lord, page
D 1 to
35.
4, page 47 to 62. Made to the respondent number 1 to 4.
Somebody is claiming right over the property.
My lord, what has happened, please, my lord? It measures 29 acres. For a moment, please, my lord, may.
Not going in.
My lord, if others are claiming, then I'll have to seek instructions and make my submission. But this is out of 29 acres, they are claiming only 5 acres, my lord.
Government. You come to page number 21. You read the order of the Tahsildar. The Tahsildar orders clarifies that the land was forfeited to the government because due to non-payment of land revenue. Okay.
Yes.
Now the person in whose favor the land was granted, he has a right to claim back
Yes, yes.
after
Okay.
paying the necessary land revenue along with the necessary penalty.
Yes, yes.
Now it is forfeited to the government. It is remaining as it is. Now, the petitioner, who is probably a rival person or whatever, he comes and makes a request to you stating that RTC, the government's name has to be mutated in RTC.
Well, now the explanation will be given because some period was given for all these people who were in arrears of land revenue to pay the revenue so that the land could be my lord, given back to them. Now that period has expired. So sir, you entire file ಕೊಡಲ್ಲ ನೀವು ಅರ್ಧಂಬರ್ಧಂ ಕೊಡ್ತೀರಲ್ಲ.
I'm sorry. My lord, page 22, there's an order, please, my lord, reserving 5 acres, wherein remaining portion were been given to the.
This one was for the competent authority, Tahsildar to decide the representation.
My lord, giving valid reasons, my lord.
Within 8 pages.
Yes.
So at this stage, learned additional government advocate paragraph. At this stage, learned additional government advocate invites attention of the court to the communication dated annexure A, communication dated 2388 at annexure A, the contents of which reflects that a third party, one Chikaya, son of Balaya, has staked his claim
Yes, my lord.
respect of the subject matter land to be of his private owner. This aspect may not be ignored by the.
No,
may not be-
yes,
may not-
yes,
May
yes.
not be taken in, may be taken
Into consideration.
by the competent authority while deciding the presentation. It is also clarified that this order, which by which the competent authority is required to decide the representative petitioner shall not come in way for any third party who may have interest in the land to agitate their rights in accordance with law. So your task is easy. Petition is
My
not-
lord, the time had been given to them to repay the areas which has.
Oh, limited observation. Please,
My lord, complete
Court is not-
copies are not given, my lord.
this court is
Handicapped.
merits of the case of the merits of the subject matter, this petition. Yes, next.
Green bench matters, seal number 7. Monica Pat.
Is given the order transmitted for the previous.
Next time I will not, with the young.
So this,
Yes,
sale price of iron
yes,
with the threshold value of 35%
please. We, my lords,
is decided by the IBM.
no, now IBM is expected to quote a price, average sales price for this 35%.
It is quoted, you are bound to.
No, but we are not, in fact, the rule says, my lord, that IBM is expected to do so at 35%. There is a obligation upon them to do so. We have come before this honorable court only for that purpose. Now, my lord, in the absence of which, my lord, we are expected to pay at a higher grade.
That obligation in the rule, some rules.
So, yes, my lord, the rule 39, sub rule 3. ಇದು court officer, minerals, other minerals, carbon rules 2016. Court officer.
Yes, sir.
ಮತ್ತೆ ಕೊಡುವ 39.
Page number 413. Approximately. 413. ಇಲ್ಲ.
But these are rules known as the minerals other than carbon mineral concession rules 2016. Payment of royalties, not rule 39, sub rule 3, if lordships have to get it. Where the act specifies that royalty in respect of any mineral is to be paid on an ad valorem basis, the royalty shall be calculated at the specified percentage of the average sale price of such mineral grade concentrate for the month of removal consumption as published by the Indian Bureau of Mines. Now,
Today, what is published? 45%.
yes, they have not published 35. They have published other things. We are not really They have to publish it. We have come before lordships only for that reason. There is an obligation cast upon them. They have to publish.
Court compel them to publish.
Well, they are bound to. If not, the difficulty for us is not. We are.
They have published to be at 45%.
No, they have published. They have published below 45 to 51.
There accordingly you are paying.
No, we are not. Lordships will kindly permit me to make this statement. The grade of 35 and 45 differs. Price differs hugely. In fact, it is double.
This must be a case where the obligation is there, but there is no enforceable right.
No, in fact, lordships may kindly see.
An obligation under the rule.
Yes,
publish a particular threshold.
Please.
But then if it is not published, then there is no enforceable.
No, under section 9 of the MMRD Act, I am expected to pay royalty and ad valorem basis on the basis of the average sale price. Average sale price. For instance, if lordships permit me to demonstrate, 35 grade lots is about 68 rupees today per ton, whereas this 45 is 128 rupees per ton, practically double. Section 9, the substantial section says it is ad valorem basis on the average sale price. May I request lordships to kindly see section 9. Rule 43, in fact, the same, they have to publish. In fact, lordships may kindly permit me to read 43, 43, there itself, those rules itself. The Indian Bureau of Mines shall publish the average sale price of each mineral, every month. But they are bound to do it. If not, it is simple. It is a very simple formula. I am expected to pay royalty to the government. I have to pay commensurate with the kind of grade I am manufacturing. I can't be asked to pay. All that we are saying is let them publish it. Manner of computation is also given.
No, I have one submission to make, which may be in favor of my learned friend.
Mr. ASG, see, now obviously you cannot prescribe an average sale price for each percentage grade FE. Correct?
Sorry to interrupt.
No, it can't be 1%, 2%, 5%, like that.
No, 35 range. There is a range.
It has to be a range. So
Yes,
in their competence.
yes.
What if they say up to 45 grade FE? This is the average sale price.
No, Lord, these are categorized. Below 35 is a different kind of grade itself.
Are you able to show it?
Yes,
the
Lord, they have
provision of
done
law?
so. 83,
Lord,
Lord. Anyway, what Malanet
Lord,
wanted to say something.
Two submissions. According to the IBM, any ore below 45% is considered as waste in India. It does not have any value. So therefore, it's a waste. Therefore, by a notification issued in excise of power under section 18 of the MMDR Act, we have said that any ore which is below 45 shall be treated as 45 to 55. That is one thing. Having said that, my lord, my request is, your lordship may kindly consider allowing the writ petition itself in part by granting relief number 1. He has placed some material before us. He wants us to take a decision. We will take a decision within 2 weeks. Please look at prayer number 1.
My lord, I object. We have issued the demand notice, my lord. The deputy.
Anyway, as far as
Forest.
the
No,
central government
yes, my lord, the second
Not this
prayer
case.
must be seen.
Madam, not this petition.
No, I'm concerned
Serial
about,
number 8.
I'm concerned about WP 35246. The petitioner has placed some material. He wants us to consider and take a decision. No, prayer number 1 is that issue a writ or direction in the nature of Mandamus directing the respondent 1 to 4 to consider the petitioner's representation dated 1911 and 14/9/23 and provide for average sale price for grade so and so in accordance with rule 42. It is made in 23, but we have not considered. Lordship may give me 2 weeks time. We will take a decision on that, whether it is possible or not. We will consider all these aspects and we'll take a decision. The other reliefs are consequent to this in the sense, because I have not disposed of this representation, the petitioner has sought for relief number 2 and 3. We will take a decision on this representation within 2 weeks from today, in accordance with law. So Lordship may partly allow the writ petition and dispose it.
But fair enough, but I must bring to Lordship's notice, the government of India itself has bifurcated this 45 and 35 separately. They don't say it is waste. May I request Lordships to kindly see page 83.
Hello, we'll consider all that.
Let them also take into consideration these things.
Yes, we'll consider.
In all fairness, if ASG says that they'll consider, I will not have any objection. Lordships might defer it by 4 weeks. Let them consider it, and so that we will not be asked to again re-agitate the matter. My only request, Lordships might defer it by 4 weeks. Let them consider it by 2 weeks and make a report. In case we are satisfied, we'll withdraw the petition.
My objection to this would be in this the consideration of that. If we
Some
accept
difficulty, we can again come back to unnecessarily. We'll have to again come back to Lordships by way of a fresh petition.
all right, no difficulty. We will communicate whatever our decision is within a period of 2 weeks. That is the stand of the central government.
While the court heard learned Syrian advocate Mr. Muragi for the petitioner.
Next one, madam, jump.
Yeah. Apprised the court about the controversy involved in the petition in light of the order passed by the coordinate bench on 24/12/2014, June 2024. It could be noticed from the prayer clause in the petition that one of the prayer advanced by the petition for all
Serial number 35.
practical purposes,
Same company.
is to directly for authorities to consider the petitioner's representation. It is 19/11/24 and 14
Different company. Same facts.
for providing for average sale price fixation of each grade of iron ore according with rule 42 of the other than atomic hydrocarbons, energy, minerals,
Okay.
concession rules.
Separate.
Prayer
Separate.
in view of the in light of the above prayer, learned additional solution is fairly submitted that the competent authority of the Union of India shall Consider representation. And
IBM.
Communicate the decision within 2 weeks.
why should we keep it pending?
But I am hopeful, my lord, they will consider our request favorably. For some reason,
Consideration is
my lord, it
100%.
is not done, so my lord, I may have to again come back before the lord. But it will only prevent multiplicity of proceedings. Of course, a loss of brief for my learned friend, but I will say, my lords, it would prevent unnecessary litigation.
Communicate. Petitioner express the hope that he expects an objective decision. Full stop. In light of the above, in light of what transpired in course of the year, and in view of the above prayer, which is to be attended by the competent authority, this court does not see any good reason to keep the petition pending. Petition is disposed of with the hospital observation direction without going into or expressing anything on the merits of the subject.
Grateful. Extremely grateful.
There is one other matter, my lords, on the board today, similar to this. That is serial number 31. Yeah, it is by a different company. Exact same similar facts of the case.
Same order may be passed.
31. Same.
Item 31, item 30.
Same order.
31 will just give 31, the recess and same order.
31.
And one thing, yesterday, I forget, yesterday in that Dharwad and Kalburgi meeting, who recorded appreciation of the authority. They will say that fair enough to, they have taken a fair stand, but appreciation will be for Nilofer.
Oh, I'm obliged, my lord. I'm obliged. It's very touching, my lord. It's very obliged. I'm obliged. It's touching. I'm obligated to my lord.
That is just a passing thought in my mind after we rose, but forget in the at 11
No, I'm obligated, my lord.
for your effective and objective assessment.
Grateful.
31.
So items 7, 8 and 31.
No, 8 is different.
8 is different.
I'm sorry.
So-
8 now will.
My lord, 8 is, we'll have to consider it, my lord. A detailed representation has been given.
So this will take care of which or 7?
7 and 31.
7 and 7. Yes. There also, Mr. Naudagi, you are appearing.
Yes, same.
Legal order you passed, then I'll check.
31. Let it, submit it. ಈಗ neat and ನಮ್ದೇನ್ role ಇಲ್ಲ? ನಮ್ದೇನು?
ಅಲ್ಲಿವರೆಗೆ ಲೆಕ್ಕ ಮಾಡಿ.
8 and 70.
You can tell what this is for us.
This is deemed extension has to be coterminous under the master.
Correct. Coterminous would be. No. Yes, yes.
Now this compensatory forest fee,
Yep.
station fees required to wait for what purpose? For granting quarry.
You know, what happens is, Lords, when we do mining in forest area, Lords, then alternative land, Lord, they will do afforestation. For that we have, according to us, we have already paid. Then, Lord, there was some difficulty with those lands. So they asked us to give some other lands. We have given some other lands. So they cannot, they have asked, made a fresh demand, which is impermissible according to us.
So extend the land.
Yes, exchanged the lands, exchanged the lands.
Detailed representation as per annexure S and T, page 110 and 114.
Basic argument appears to be that this afforestation fee has no basis in law.
My lord, for that they have made a representation. Let the authority consider that representation and pass orders in accordance with law, because the demand is of, demand notice is dated 26 September 2024. And so far, nothing, no action has been taken by the Deputy Conservator of Forests. So if my lord were to grant him some time to consider this representation,
SNT or for what?
my lord, representation is to be considered by the Principal Chief Conservator of Forest for a notice issued by the Deputy Conservator of Forest. And that is their prayer also too.
If my learned friend wants to make a statement, my lord, that they will consider our representations both for prayer number 1 and 2, I have no objection.
1 and 2 is seeking for quashing, sir, for which you have filed objections.
No, which objection?
You have filed objections because that is issued by the Deputy Conservator of Forest. Now you have, being aggrieved by the demand, you have written to the Principal Chief Conservator of Forest. My lord may direct the Principal Chief Conservator of Forest to consider this representation in accordance with law because they have given detailed reasons.
If my learned friend says, my lords, our objections to the demand notice will also be considered by them, I don't have.
Sir, that is what you have done in an extra SNT.
Keep effective until order is passed. Practically, it will be still.
So today, there is no forest clearance.
No.
No. Forest,
What is this deemed extension of?
no, that is second one, my lords, is, initially we were given, my lords, 20 years approval for forest area. Now, my lord, by way of an amendment to the MMRD Act, my lord, the lease came to be extended. Therefore, our mining lease also extended. Therefore, correspondingly, this deemed extension for forest clearance also has to be given. It is more ministerial in nature. I must bring to lordship's notice. Forest clearance extension must be given. The reason is, my lord, mining lease stood extended. Accordingly, my lord, automatically it is also has to. It is coterminous.
Both these prayers are not interconnected.
They are not interconnected. They are not interconnected. Therefore, what my learned friend says, not if I have understood my learned friend correctly, what she says is not that I have filed my objections to this demand notice. They'll consider that objections to demand notice and pass orders. That is what my learned friend says.
My lord, the
I have understood.
representations are given as per annexures S&T, page 110 and 114.
S&T are different. S&T is for deemed extension of forest clearance.
So deemed extension depends upon the demand notice.
No, nothing to do with, nothing to do with, nothing. To do. So
Then what will happen to second prayer if we?
No, first prayer, if it is considered, my lord, I think second prayer, if it is considered, then I think the first prayer there might be a change in that. Yeah, very well. If they want to file objections to the deemed demand notice, let them file their objections. My lord may grant them some time. We will consider those objections along with the representations given and pass orders in accordance with law.
About first prayer.
First player, if they want to file objections, my lord, to the demand, let them file objections. And for the second, my lord, to consider.
Right.
We are asking if we dispose of the petition on that line,
Yes.
what will happen to second prayer?
What they are doing
Consider, my lord, because that's
without
just,
reference to Annexure A. That's what we are saying. Without reference to Annexure A, our representation for deemed extension must be considered. No, of course, yes, because they are asking us to make the payment.
The prayer for deemed extension may be considered after you take decision.
Yes.
my lord, for that, that is the reason why instead of it being step by step, if my lord, if they have objections to this demand notice, let them file their objections, my lord. The representation for deemed extension is there.
1 second, if the two prayers are not interconnected,
No, what they are doing
why
is
don't you, we reserve liberty to file a press proceeding for second prayer and dispose of this petition qua the first prayer?
no, what they are doing, if I may have to bring to no, but they are not ready to consider our representation for deemed extension on the ground that there is a demand notice until you make that payment. But may I request this?
My lord, may I make one submission?
The representations at annexure S and T are made subsequent to the demand notice.
Yes, my lord, that has a reference in page 112.
In the context of, what they, 1 second. But annexure, simple mode, we had requested them for extension of our deemed extension of forest land. But then they came up with this demand notice and said, unless you make that payment, which according to is without any basis, we will not consider your representation. Therefore, Lord, in the representation, we also say you drop that demand under annexure A and consider our representation for.
Now,
My lord, that
This-
finds a place in page
No.
112,
No,
my lord, the
madam-
second paragraph.
Madam, 1 second, that's why I'm asking you. These representations at annexure S and T
Yes,
are in reference to the demand notice raised
Yes.
at annexure A.
yes.
So you are required to consider representations at
Yes.
annexures S and T and pass appropriate orders.
That is what I've been submitting.
No, but the
That
stand,
orders in
no,
accordance
the
with law.
communication they have now made to us, which I must bring to lordship's notice is, unless we fulfill this demand notice amount, they will not consider our.
Therefore,
Yes.
therefore, two prayers are inextricably interwoven. The second prayer cannot be granted unless the first prayer is granted.
Correct, Lord.
Yes, my lord, that the mention is made by the petitioner at page 112, paragraph 3.
So we view that you succeed in the second prayer, provided you succeed in your representative.
Yes.
Insofar as that demand is concerned, it's without any basis, Lord. That is something, Lord, which they must consider. If my learned friend says, Lord, they'll consider this independently, but I have no objection. They must consider it independently.
Linked in the
No, they cannot act like
So we can say that second prayer may be
considered independent.
maybe agitated after the decision, the first in relation to the representative.
My lord, for a decision,
After.
my lord, for a decision for a demand,
So both are based on same cause of action,
yes.
both the prayer.
No, but what the government now is doing, my lords, is they are trying to, my lords, hold us literally, my lords, in, I won't use the word ransom, asking us to pay the money before they consider our application for deemed extension.
But the point is, after, see, the date becomes important.
In fact, Lord, this honorable court has already directed them to consider that.
A is passed on 26/9/2020. Annexure A is passed. Then, see, this is the demand, this was 1/1.
Lords, may I? Lords, may I? Sorry, sorry, my lord. The previous occasion, but there is already a direction on 24th of December. But this honorable court has already directed them to.
There is a reference to this particular letter, DC of Ballari demand office also CH-1. They have made a representation. And then there is again, there is a representation of 6/11. The petitioner have taken up a contention stating that they are not liable to pay the said demands. So after passing of annexure S and T, there is no
May
fresh
home.
order. I mean, after the
May the court.
presentation of the annexure S and T, there is no fresh order. So after representation at annexure S and T, there is no fresh order from the government.
There might be a fresh order because we are
No, there is no
considering
fresh
it.
order.
My
No
lord,
order.
the demand,
No, I'm asking you, have you passed a fresh order?
No.
no, my lord, this came up on 24/12 and this is the second hearing
But
date.
the one thing I did not bring to lordship's notice, on 24th, there is a direction by this honorable court, directing them to pass orders on forest clearance. Lord. May I request lordships to kindly see the last direction on the order passed on 24th. The first respondent, the last sentence. First respondent is also directed to consider the petitioner's request for forest clearance in the light of the interim order now granted and place on record its stand in for further orders. So there is already a direction. This interim order was there to grant stay of the demand, Lord. They have to pass orders now on the forest clearance. This you should have shown it.
My lord, please see the reference, please see the subject in demand notice for CA charges, my lord, annexure A, page 30.
So this deemed extension will depend upon the determination of this notice.
Yes,
No, according to us, they are totally, no, in fact, page 97, no, they are not linked, Lords. What the state is trying to do is, Lords. Page.
What happens?
Here.
Then this observation is the next page. First opponent is authorized to consider the petition as status for forest clearance in the light of granted and based on the persistent. What is the interim order? The interim order is staying of this annexed area. The observation is in second paragraph, first page. Previous page. Petition is agreed by the demand notice, which is the demand case. Petition has to be decided by this board. But paying of compensatory aforestation fee in the year 2005 would make them liable to.
The question was as to whether. But may I make this request? The question as to whether or not they are right in demanding this forestation fee is to be decided by a lordship. Not either way, not we will take. Insofar as the direction to consider our insofar our request for consideration of our extension, which is deemed, which is automatic in nature.
Was that the forest clearance is withheld because of notice?
Correct, not correct. Even now also that's what that is the submission. Even now they are withholding our forest clearance, lords, on the pretext of this demand, which is nothing to do with this. But that has to be decided by your lordships. In fact, the government of India has now said, has communicated to them to give automatic.
Justify your right to claim, demand this forest.
Yes.
Aforestation fee.
My lord, then what happens to prayer number 2, where they have
Let them consider
taken
it. Let them consider it.
my lord, demand for
They succeed in the
Help-
first
help.
prayer. If the notice is stayed by the earlier bench or coordinate bench, then they will succeed automatically in second prayer.
my lord, the second prayer is only to consider the representation
them
with
do it.
reference to the demand notice for CA charges. My lord may see the subject in that.
My learned friend says they don't consider it not per second prayer. I have no objection. For first prayer may be considered by your lordships whether the demand is justified or
No,
not.
second prayer is in continuation of the first prayer. They cannot be bifurcated, and they themselves have said that.
Bifurcated, but then both cannot be simultaneously decided unless the first you decide on the.
Yes, ma'am. Please, lordship, let them file their counter, let the lordships
My
decide.
lord, my submission is the representation will be considered. Our reply, my lord, they will get a reason from us after we consider their representation. Then they can come before my lord and say, this is not what it is. Then I will justify to my lord.
But today demand
Staying
notice,
away today-
demand notice is made for payment of not for aforestation charges. According to us, it is without any basis. Let them justify as to how the matter could be decided. It's not very
My lord,
complicated.
that is raised in the representation, my lord. How can
I'm
it
sorry,
be
I do not, my
bifurcated?
learned friend has
And
to
no
justify.
action has been taken from September 2024. Let my learned senior be fair, my lord.
No, government advocate, see, by virtue of Annexure A, you have demanded compensatory afforestation fee from the petitioner. Thereafter, he has submitted a representation stating that how he is not liable to pay the same.
Yes, my lord, that is
Okay.
because for extension.
Now yes, now you already taken a decision by virtue of Annexure A.
And then my lord. has
See,
done his
if you accept his representation, that means to say you are overruling your own order at Annexure A. Instead, you file your objection stating
Very well.
whether you are standing by Annexure
Yes,
A
ma'am.
or you are going to concede by
Considering
looking into the representations made by the petitioner. So once and for all, it will be decided.
Very well. Yes, my lord.
That is also a proper course.
Well, yes, my lord. Yes. I will find.
Instead of answering the petitioner, you answer us.
Yes, my lord, I'll do that.
Interim order is there until further.
Anyway, interim arrangements are brother by virtue of this order.
In light of the order passed on 24/12/24. Learned the additional government of advocate, Mr. Nilopar, would request that respondent to refer to file a reply to justify the legal basis for the demand notice dated 26/9/24, asking for the payment of sum of rupees 9,76,75,200 towards compensatory aforesaid fee from the petition. Full stop. Necessary affidavit may be filed before the next hearing. Put upon 4th February. Or
A little,
little longer. 17th February.
okay.
Please.
This seal number 9 urgent, writ appeal, seal number 10, Manu K.
It's after for the appellant requesting for a short accommodation.
For the accommodation. Yes, ma'am. Serial number 10. There is a delay of issue notice,
My lords?
delay of 70 days.
Yes, my lords.
Notice
This is-
written in 18th of February. Notice in delay.
Seal number 11, TSP Total.
For the appellant. My lords, the
Same, notice, 19th February. Notice in delay.
my lords, one second. I may be permitted to serve a copy to the advocate who represented in the writ
In
petition
addition to the formal mode of service,
to the respondent.
party, responding party, learned advocate petitioner is available to serve copy of the petition to learn to appear
For the respond number 3 to 32.
for 3 to
32,
32 appeared before learned assembly.
please. Achok.
So in which matter? 11.
11. Seal number 12, state appeal. Lord, state appeal, my lord, there's a delay, my lord.
State appeal
Here for the
notice.
respondent.
Yes,
delay, my lord.
Delay may be controlled.
Notice will have to go in delay.
To respondent number 1, my lord.
Notice. To respond one, returnable on 19th.
Seal number 13, Shivan and DS.
Appearing for the contesting response in the matter.
But I am for the appellant in that case. I am representing the appellant, my lord, and my lord, before that, my lord, some preliminary submission, my lord. The impugned order dated 10/1/2023 previously was challenged by the association, my lord. So as per Annexure G, may I request your lordship to see in the first writ appeal, my lord, in my writ appeal, Annexure G, my lord. That is Annexure G may kindly be seen. Page 96, my lord. That is, my lord, it starts from page 94, my lord. Annexure. Annexure J is the final order. Sorry. Same impugned order dated 10/1/2023. Page 94, my lord. It starts from page 94. Previously, that interim order was stayed by the single judge, and finally, the writ petition is disposed of, my lord. I mean, dismissed. So paragraph 3 of the same judgment may kindly be seen, my lord. Paragraph 3. Further, may I read, my lord? The runner SCGP for respondent number 1, upon instruction, submits that the impugned order will be implemented only against the persons who are party to the proceedings, not against those who are not a party to the proceedings before the first respondent. Tahsildar. If anybody has to be evicted pursuant to the impugned order, the same shall be done, will be done only after affording them an opportunity of hearing, my lord. Against this particular, my lord, order, my lord, one site, one, because this writ petition was filed by the owners of the site, my lord, in that locality. Therefore, writ petition was dismissed because it is on the ground of local standing. So then, individually, if anybody is aggrieved, the individual site owners could file a writ petition that was filed, my lord. That is subject matter of present writ appeal, my lord. Now, again, this particular paragraph 3, my lord, one of the site owners, my lord, has initiated the contempt proceedings before this court. That is, my lord, in CCC number 1131 of 2024. my lord. May I request for lordship to go through the order sheet in the contempt. Order sheet in the contempt proceeding. That is, my lord. Yes, ma'am. That is 15, 11, 20, 20. This, may I read, madam? Same paragraph 3 is extracted. While dismissing the writ petition by order dated 23/6/2023, none single judge observed the following. Further, the HCGP, the paragraph 3 is extracted. Upon instruction submitted, the impugned order will be implemented only against a person who are party to the proceedings and not against those who are not a party to proceedings. Before the person, if anybody has to be evicted pursuant to the impugned, same will be. So that is why, my lord, this court, my lord, has issued notice, my lord, and on Monday, my lord, may I request, my lord?
Appeal is to be conducted independently or?
Appeal is to be
But,
considered independently.
No, no.
Absolutely,
May I make
the orders which was passed, earlier by the learned single judge is not challenged. That order, dismissing the writ petition because there is no operative order itself. There is no positive direction. It was only a statement which was made by the learned government advocate. Now, that was the very contention which was raised before the learned single judge. I can understand, if this contention is arising for the first time. This was the very contention which was raised before the learned single judge, the order which is impugned before your lordships. The learned single judge considered, page number 38, paragraph number 13 of the impugned order.
So this is relatable to which writ petition?
What now my
That
learned
is the
government is
second-
referring to. Yes,
Madam,
this is completely independent. Now, that was the earlier round of writ petition which was filed by an association. Writ petition was dismissed by recording the statement that if at all anybody is required to be evicted, we'll give notice to them as a statement made by the learned government advocate. So that writ petition came to be dismissed on the ground of locus standi because association was before the court. Now, there is a writ petition which has been filed by the independent owners. They claim to be the owners of the sites which has been purchased by them, number one. And there was an order which was passed by the Tahsildar, which is based on the order of the Deputy Commissioner, which we sought for enforcement. Both the matters were clubbed together, and the order is passed by the learned single judge, where he says that they all had approached the civil court by filing suits for injunction. Findings was categorically recorded that they were claiming under sale deeds, which was much later in point of time, when the title was not vested in their vendors, number one. They did not establish their possession to the property, and therefore their remedy was to pursue the remedies only before the civil court. They cannot come before the dishonorable court and then seek to pursue the remedies. So whereas the orders may not pass by the Tahsildar is concerned, the learned single judge directed that it is for the Tahsildar to seek implementation of the orders. This is the only order that has been passed by the learned single judge. Now, the contention which is presently being raised is nothing pertaining to the present case, because what was the contention which was raised pertaining to the earlier litigation was actually raised before the learned single judge. The learned single judge has considered, probably when they filed the contempt proceedings, they have not brought to the notice of this honorable court while issuing the contempt notice that this came up for consideration before the learned single judge, and learned single judge has not accepted this contention. There's already a finding against them. So probably they have withheld this material when your lordship was dealing with the contempt proceedings. Para 13 minutes is exactly where they refer to the same paragraph by referring to paragraph number 3 of the order dated 23/6/2023. In writ petition number 2074 of 23, it is contained by so and so that this court has recorded the undertaking given by the High Court government period to implement the order, so on and so forth. This is not accepted. Para 17 minutes is the findings. At page number, internal page 29, page 42 minutes, about 4-5 lines from the beginning itself. It is to be mentioned that Sainik Vihar Site Owners Welfare Association filed WP number so and so challenging the order dated 10/1/23, passed with the Tahsildar Yelahanka. Said petition came to be dismissed on 23/6, the submission of so-and-so, appearing for petition so-and-so that unless the said order is reviewed or clarified, the relief sought for by the petition is not maintainable. In the backdrop, I have carefully examined the prayer in so-and-so. Petitioner sought for implementation of the order dated so-and-so passed with the North Taluk. It's the grievance of the petitioners in WP number so-and-so that the petitioners in the other petitions have filed various suits. OS number 665 of 2007 and connected suits which came to be dismissed on 31/7/21. In the judgment passed by the suits, the trial court at para 53 to 55 have given a finding that plaintiffs therein who are the petitioners in the connected petitions have failed to establish their right that the sites that have been carved out of the lands bearing 33 and 34 of Kenchanalli. Trial court also gave a finding that plaintiffs have not established their position in respect of the sites and therefore dismissed the suit for ban injunction, directed the plaintiffs to file a suit for declaration consequential relief of injunction. Undisputedly, except the petition in WP number so-and-so, the petitioners in the remaining writ petitions have not produced any materials before the court stating that they have preferred a suit seeking relief of declaration in respect to the subject sites. I am of the view that the arguments advanced by so-and-so as regard the necessity of clarification or review of the order cannot be accepted on the sole ground that the writ petition filed by the petitioner therein is dismissed as the petitioner society has no locus standi to challenge the same by the order dated 10/1/23 passed by the learned by the respondent Tehsildar, and also in view of the disputed question of fact that are involved in this. But probably they have not disclosed the orders of the learned single judge in the instant writ petition.
The property is situated in DBFL.
No,
What's the called KLR Act?
KLR Act itself is not applicable area.
The basic order that has been passed with the order itself is illegal. That question has not been gone into the learned single judge.
No.
There is a high number of segments wherein it says if the property is situated within the BBFL limit, KLR Act is not applicable. So therefore, Tehsildar has no jurisdiction to pass such an order, directing the authorities to remove the layout. Therefore, that question has not been gone into by the learned single judge. The basic, there is a error of jurisdiction by the Tehsildar in passing the order for removal of the layout. This layout has been formed in the year 1986. 300 sites are there. Almost 60% of them have already built their houses. They are living there. BBMP has issued a khata. Taxes are also collected. Now, all of a sudden, now Tehsildar enters into the picture and he issues an order for removal of the layout. The basic inherent jurisdiction itself, Tehsildar is not.
I think that's.
That question has not been gone into by the learned people.
My lord, another.
Actually, that may not be correct because the proceedings regarding this unauthorized layout came to be concluded by the orders of the Deputy Commissioner in the year 2014. The order which they are now impugning as the orders of the Tehsildar refers to the directions of the Deputy Commissioner of the year 2014. Whatever now they are referring to is an amendment which has come about after 2018. But it's ultimately for them to establish their.
Yes. Now, whom do you represent, Ravi Shankar?
I am representing the persons who are the owners of these properties. Just two sentences I will state to you. Survey number 33 is the subject matter of the subject matter of the instant writ petitions. Admittedly, the property belongs to SK Mariappa. I will start from SK Mariappa because they are also claiming title under SK Mariappa. Now, since SK Mariappa sells this entire extent of property on 21/1996, which he had acquired in 95, he sells the entire property in 1996. Not in favor of the present respondents.
That is R2 and
yes.
R2 and 3 or only R2?
It is to my vendor's vendor.
Okay.
This is sold in favor of Sham Sundar Batija. Sham Sundar Batija purchased the property on 21/1996. Then after Sham Sundar Batija has purchased the property, revenue entries are continued in his name in the RTCs. Azmatullah Khan, one of the respondents before a lot is purchased in 2016 that entire extent of survey number 33, which was then folded into 3-4 parts. This Mariappa appears to have died on 19/3/2004. Once Muhammad Salim claims that there is a power of attorney executed by the legal heirs of Mariappa after 2004, and the claim is made that the present persons have purchased the sites from the legal heirs of Mariappa through the power of attorney holder Muhammad Salim. So there is no layout plan, there is no authorized layout, there is no conversion, nothing is there. Lord, these proceedings was initiated, Lords, way back in the year 2014. In 2014, they said that you cannot permit the user of the agricultural property for non-agricultural purpose. Deputy Commission passed an order on Section 96. The Tahsildar order is only consequential to that. Even the Tahsildar order which was passed, Lords, came up for consideration before this honorable court at the instance of an association. That writ petition came to be dismissed by recording that whoever is responsible. Now, Tahsildar, after that, passes an order. The order which is under challenge before the learned single judge, what was not what came up for consideration before the previous writ petition before the learned single judge. It is another order. There, the Tahsildar takes into consideration to give a notice, they should have something subsisting interest in the property. What was brought to the notice of the Tahsildar is that all the suits which were filed by them was dismissed by the civil court. This issue came up for consideration. What is due process of law? Once an adjudication takes place and they have already suffered an order, due process of law is complied. It is not that at every stage they will be entitled for due process of law. Once they have been afforded an opportunity, the due process of law is complied with. Now, the Tahsildar only says this. The title is with the Azmatullah Khan because there is a series of sale deeds, revenue entries are there. Now, some people wanted to come and say that 2004, 2006, 2008, we do not know when.
Who all went to the trial court to establish their rights?
It's about 60 of them went before the trial court. 60. 60 of them went before the civil court. 60 of them went before the civil court. Those suits were filed for bare injunction. Finding is specifically recorded by the civil court because issue estoppel arises. Finding is specifically recorded by the civil court that they did not have any interest in the property on account of S.K. Mariappa having lost the title in 1996. They are claiming under the sale deeds of 2004 and onwards.
So what happened to your declaratory suit?
Not so far as my declaratory suit is concerned, my lords. The suit for injunction came to be dismissed. And because there was a specific observation which was made, I withdrew the suit because the finding was already recorded in the injunction suit saying that the title which they are claiming is subsequent to my title and therefore there is no question of claiming any title to the property.
Okay, so here section 192A order is passed, is it?
192, yeah.
Lords, this is section 96. There is a power vested with the deputy commissioner.
Let's see.
Section 96(1).
1 second.
Sorry, my lords, my apologies.
It's 192A order, right?
Yes, madam, 192.
Section 96(1), if your losses were to.
No,
speak, not-
192.
No, 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 this
Table
order,
5.
Karnataka Land Revenue.
Yes.
Karnataka Land Revenue Act, section 96(1).
No, this order is passed under what?
That is 192.
It's an order which is passed as a consequential order to the directions issued by the Deputy Commissioner of 2014, which is not under challenge. Lordships may kindly take WP number 1505 minutes because the translated copy is available. Only in this, in the other matters, the translated copy is not available.
My lord, the Tahsildar
Then note of
order,
an order which has already been passed under section
my
96.
my lord. Tahsildar order, my lord, dated 10/1/2023, my lord.
Page,
1 second, Avishika, we come to you. Where is the impugned order? Show me the impugned order.
page 89 in WP number
No, no, no.
1505.
In this particular
There
thing.
that translated copy is not
That is my page, my lord.
It's 78.
Annexure G, my lord.
page 78.
78.
In my, the first writ petition, appeal, page, my lord, 78, my lord.
Translated copy, I think.
Yes, that is also produced.
Num copy ಇಲ್ಲ.
Translate copy also I have produced.
Good copy is incomplete.
Annexure, my
Sorry.
lord, page
not-
85, my lord.
It's may. Because,
My lord, before that.
my apologies, my lords, that my learned friend has not furnished the,
Translate copy.
no, it's not furnished to us in our papers. If I can only request if your lordships were to take writ up in number 1505 minutes, because we have those paginations. My learned friend has not furnished.
Yes, what is that? That entire layout has to be vacated. Table either table files. This table files. Yes, order as per table files.
192.
He says the operative portion of the order. English, where is it?
It's
provided?
page number 89. in
I have
writ up in number
produced one.
1505.
I have
minutes.
produced in my writ appeal. Page,
ಇಲ್ಲ ನೀವು
Translation
office
ಇಲ್ಲ.
refer ಮಾಡ್ಬೇಡಿ.
Illa, where is the, we don't have that English translated copy.
it is there. In writ
Your
appeal
lordships may
number
kindly take writ appeal 1505 minutes.
1531, it is there.
Which page?
My lords, page number 89. Translated copy.
ನಮ್ದಿದೆ.
No, 1 second, no, it's there.
It is there, not page
88,
number. My lord, I have produced. my lord. Page number 85, my lord. In my writ appeal.
It's in that, the 91, I think, lords, the last but one page. My pagination is correct.
In my writ appeal, it is there. translated copy.
That is the appellant's request regarding Alanka term so and so.
Yes.
See, according to table 5, where is the question of
Yes, madam.
him being evicted? It is for actually.
96(1), if you, Milords, kindly have a look at the orders. That is 10/1/2023. Milords, there is no paragraph, just the last but one page, Milords, page number 92 in my paper book. I think it should be 91 or so, Milords, because in that writ appeal. It is not, Milords, the proceedings which is initiated for the first time by the Tehsildar. This is pursuant to an order which was passed with the Deputy Commissioner.
This is
96(1).
the regular revenue side.
Milords, kindly have a look at section 90. Kindly have a look. Milords, now the question is this. What the Tehsildar takes note of is that the suits are already dismissed. They have not gone before the civil court. Nobody else has gone before the civil court. Milords, kindly have a look at this page 92, the last but one paragraph, Milords. I just read that particular portion, Milords, in that orders of the Tehsildar.
That is 150.
Yes, 1505, page 92, Milords. I don't know if the translated copy starts at page 89.
This appeal is confined to one petition only.
Milords, there are about 7 petitions.
All are connected.
All are connected. All are appeals.
4 petitions, Milords. There are 4 petitioners only.
So it has to be addressed individually, not collected.
Yes. Milords, I can do one thing, Milords. I'll file a very short synopsis, Milords, of. Because ultimately, Milords, the question of locus would still arise. If they don't have any subsisting rights over the property, the question of entertaining a writ petition would not arise. In the teeth of their civil suit having already been dismissed.
May I make, my lord?
No, in 17208, the learned single judge said they implement the order.
Yes.
It is allowed.
Yes.
And in the other petitions, the parties.
Dismissed.
Parties are relegated. They are required to, because
What is the difference between the two?
Milords, 1702 is seeking to implement the Tehsildar's order.
Say
The other
10,
writ petitions
120.
are challenging the Tehsildar's order.
Yes. My lord, one submission, Lalan Singh.
What is your argument?
My lord,
Don't go here and there. What is the argument for the impugned order?
my lord, the impugned order, my lord, 10/1/2023, my lord, is passed by the Tehsildar, my lord. So that, my lord, may kindly be seen, my lord, 192A, my lord.
Is 192?
Yes, madam. Pi says, my lord, yes, my lord, that is under the that is, my lord, under the Karnataka Land Revenue Act, the Tehsildar has issued, my lord. So 192 table, well, 5 may kindly be similar. It says, my lord, sells any agricultural land for non-agricultural purpose without getting such land converted or without obtaining prior approval of the competent authority. So on that ground, my lord, independently, my lord, Tehsildar, my lord, has passed the order dated 10/1/2023, my lord. There are, my lord, there are many decisions, my lord. This is the land, my lord. The sites are farmed out of survey number 33 and 34 of Kenchinhalli village, my lord. My lord, these are fast, my lord, this land, my lord, my lord.
Yes, yes.
See,
So this requires finally.
So, if your lordships were to grant, because may make this request, Lords, I'll file a very short synopsis. Lords, I'll file a very short synopsis, Lords, not running into one page pertaining to each one of the writ appeals. If your lordships could accommodate, subject your lordships' convenience anytime during the course of the week or 2 weeks, Lords. It could be taken up at 2:30 minutes. I'll not argue the matter. I just file the synopsis and leave it at that.
Set down for final particular.
Fine.
Because, Lords, if it could be taken up at 2:30 minutes on any given day, Lords.
This will require a little.
Yes.
Lords, that's the reason why I said, Lords, I'll assist your lordships with a very short synopsis.
Your submission, your synopsis will help us, but this will fix the.
If your lordships were to fix minutes, let it be in the same stage with an understanding that the matter could be heard, Lords. At least that accommodation your lordships may give up, because this is a litigation which is spread over almost like about 10 years now, Lords. 2014 is the original order passed with the deputy commissioner.
There is a residential society.
Yes, madam.
Lords, now there is no society. Lords,
Individual
I want to
owners
correct
are-
this. Lord, there is no residential society. What they did, individual persons who claim to have purchased the sites subsequently, they subsequently formed an association.
Residences are there.
Lords, there are no residences as of today, my lords. I just
There
want
are-
to clarify this. Lords, there is a specific reference in the order which is passed by the civil court itself. Lords, civil court findings is what binds them.
Since issue involved in this, since the issue to be addressed in this petition as cropped up in light of the order passed upon a single judge and having regard to the submissions made by non-delivered parties, is whether order dated 10/1/23 passed by Dispute for Tehsildar under section 192. 192A.
Capital A.
A
through
and
to
column 5.
192A5 of Karnataka Land Revenue Act 1964.
Table 5.
192A, read with table,
5.
serial number, read with serial 5 of the table below of Karnataka Land Revenue Act would have been validly passed by him. Comma, the bills require final hearing.
May I just request, Lords, in the same stage, if your lordships may say it requires consideration.
We say that finally, we will not admit it.
Very well, Lords, please.
So we will say that finally, in that view, appeals are fixed for hearing on.
It's any date during the course of, after week after next, Lords. Subject your lordships' convenience. I mean, your lordships' hands.
4th of February.
Very well, Lords.
4th of February.
Interim order may be.
You know, interim order. is there.
Interim order.
Wherever it is subsisting, it can be extended. I have no objection.
What in the
Status quo
Status quo has
regarding
been
the
granted.
sites which are,
Status quo may continue.
of maintenance of by both the sides.
All, yes.
All
Lords, only in relation to the subject matter of their
Relation to
writ appeals.
appellate.
In relation to subject matter.
Yes.
Which is in operation. Will continue to operate.
Lordships.
Which objections will be complied?
My lord, there is a 117 delay, my lord.
In which one? Which one? So how many appeals are there? 4, 5.
This number 14. K Krishna. There is a delay, my lord,
Okay,
delay
notice,
179.
Notice.
Notice yet to be issued, my
Notice is issued or to be issued?
to be issued, my
Tenable on
my lord. I may be permitted to
February.
the state, the second, third, and fifth respondent are the state government, my lord. I'll take notice.
Government, additional government document, is except notice on behalf of 2, 3 and 4.
2, 3, and 5, my lord.
2, 3 and 5.
The 4 is there is a standing counsel, my lord, Mr. B.L.
So
Sanjeev.
the respondents will be served.
Yes, the first response also, I may permitted to serve the counsel on who appeared in the before the learners.
You need not record in every.
Number 15, Satish.
Also say in order, notice written. No.
Number 15.
I appear for the
It is the Nikanti.
counsel for the appellant. Short question is, my lord. The appellant was kept under suspension
Number 16.
with effect of 9/7/15.
15. 1, 5.
15.
1, 5. Sorry.
Delay of 36.
So there 1, 5 again, there is a delay of.
Delay of 36.
Lord, last occasion it came for your lordship, Lord, I made a submission that 6 months after suspension would expire on 8/1/2024. Rule 10(5) mandates, my lord, if charge sheet or charge memo is not issued, they are deemed to be reinstated. And 10(5) KCS rules. With a municipal commissioner. Kanditi, Annexure A, my lord, page 42.
Five of the police.
No, my lord. Panel councils are there. Respondent number 2, they have to be notified.
Necessary part.
Lord,
So five police is a
They
necessary.
may be deleted, my lord, because it's not necessary party at all. Suspension of by the director.
So that we can condone the delay.
Delay may be condoned, my lord. Interim stay may be also granted because 10(5) comes in the way. Deemed suspension will revoke after 6 months automatically under 10(5) CCA rules. My lord, kindly see.
Then 5 of this.
Yes, KCS.
That would allow
It
amount to
expired.
allowing the petition. That would amount to allowing the appeal, my lord.
It is true, my lord.
Stay is granted. My
No,
lord.
law mandates,
May be taken.
Mandates what?
my lord, deemed suspension revoked. Kindly see, I'll read that. How it,
Please,
After 90,
please, my lord.
unless reviewed. and
Please.
continue. It stands revoked unless reviewed and continue within 90 days.
no, but 10(5) says, my lord, kindly see how it is worded. Rule 10(5) KCC rules. If department inquiry is not commenced against the delinquent government servant, charge sheet is not filed in the court within a period of 6 months from suspension, from the date of suspension, that is plot 9/7/2024. Not authority shall decide whether revoke to continue suspension order, and suspension shall be deemed to have been revoked from the date of completion of period of 6 months from the date of suspension. But they can't avoid. But what happens when Chaudhry's case, Supreme Court said, currency of suspension is 3 months in the year 2014. After that, they amended the KCA rules. 6 months time is fixed. So deemed revocation after 6 months.
Sub rule 5
Rule 10(5). 10(5) clause B.
and 5 plus B.
B. Continue that also. Suspension shall be deemed to have been revoked from the date of completion of period 6 months from the date of suspension. Upon such revocation, order of suspension shall be the duty of the government servant immediately seek an order of posting from the appointing, which I have done.
So 6 months have passed.
Yes, my lord.
No
Yes,
inquiry.
pay for it. No inquiry is commenced, no charge sheet, no charge memo is issued.
Lordship may have it next week, my lord. I will take instructions, my lord. In the meantime, my lord, the respondent number 2 may be deleted from the case and delay condoned and matter may be taken up next week. I will take instructions regarding the
Condone the delay, my
inquiry.
lord. Having regard to rule 10(5)
Third point.
section of law, my lord, kindly issue interim
Third
stay,
point
my
for
lord.
consideration.
On a single has taken view there.
Dismiss it, my
Para,
lord.
page 34, para 3, my lord.
Dismiss it on the ground that he is arrested, deemed suspension will come into force. Rightly said.
It is appealed by the state.
Not by the petitioner, who is the petitioner appellant.
And this was dismissed on what?
Dismiss, my lord.
Since deemed suspension will come into force from the date of arrest, because it's a criminal case, trap case 7A, my lord. On the 8/7/2024, he was arrested by the Lokaयुcta police. My lord, the more than 48 my lord, days suspension continued. My lord, Rule 10(2)A says, my lord, if the 48 days, more than 48 my lord, hours is in custody, deemed suspension come into force. That's all. Accordingly, suspension order is passed also. From the date of arrest, he is deemed to be suspended. Therefore, my lord, 6 months expired.
1 of 24. Having heard Karnataka counsels for the respective parties, and having considered the averments made in the supporting affidavit, the present application for condoning of delay of 30 days deserves to be allowed, since the averments in the supporting affidavit make out a sufficient force to condone delay to the aforesaid extent. In the effects of the case, passage of time is not attributable to any negligence or culpability on part of the applicant appellant. Delay is condoned, interim application is allowed. So appeal may be listed on 18th,
Please, my lord.
not 18th,
Sir.
21st.
In the meanwhile, my lord, stay, because 18, Rule 5(1)B says, my lord, after exercise, automatically deemed to be instead.
Today it is beyond 6 months.
Yes, my lord. Today we are 9th.
Then will it-
Representation also given. My lord, reporting duty also.
Let back to the.
Please.
Yes, my lord. Deemed revocation. That is why, my lord. Otherwise, I would have not made suspicion at all.
20. Please, my lord.
20.
My lord, may permit you to delete respondent 2, my lord. Advocate or not, record will delete its name.
You are justifying suspension on what ground, on what, the what provision?
My lord, that 10(2)A, my lord.
Yes, my lord.
My lord,
Rightly justified. 6 months is the time. I will not object to that.
It's a trap case, no?
Yes, my lord.
Trap
Trap
case,
case.
case of trapping, my lord.
My rightly justified. I have no objection. But the law says, if the charge memo is not issued, charge sheet is not issued for 6 months, deemed to be revoked. I have to report back to duty, which I have done it yesterday. That's all my submission. I'm not making any other submission at all. On the face, according to me, suspension requires to be stayed because they don't take me on duty. Otherwise, 10(5) is not there, I would have not come before this court.
Number 16, Mr. D.S. Ramachandra Reddy.
May not be.
I appear for the appellant, that the office thought is wrong. There is no IA pending. No IA has been filed by any party. No IA is pending. But the office thought says the statement of objections to IA number 1 of 2024 filed by the advocate for the respondent number 4. No application has been filed. Interlocutory application is not filed by any of the parties. There must be some mistake, my lord, in the note. Either the respondents 4 and 5 have filed statement of objections because the writ petition was dismissed without notice to them. They filed the objections to the writ petition. Then I filed a reply to the objections. Only 2 are there. I don't know which second set is not filed. The note says second set is not filed.
After 19 years, you are seeking this.
Yeah, there is undoubtedly not application was filed belatedly. But the question is, now, Milord, I have got 3 submissions to make, if your lordship permits. May I, Milords?
Yes.
Yeah. The question of delay and latches, Milord, will be applicable only to Milord where the remedy is discretionary, like Article 226 or Article 136. As far as the authority, statutory authority is concerned, they are bound by, my lord, whatever is there in the statute book. And they cannot, my lord, dismiss the cases on the ground of delay and laches. That's one submission. This delay and laches, my lord, principle is not applicable to statutory authorities. Only limitation is applicable.
No, no.
Second point is,
Doctors have already.
Yes. So dismissed.
pardon, my lords?
We have decided several appeals on this ground.
I am aware. But only this, my lord, I want to submit. But, my lord, section 11 has not been considered. Section 11 of the Act has not been considered. And, my lord, the validity of section 2, the Article Amendment Act 2023 is still pending. Now, as regards the second set, your lordship may kindly move on the objections.
Come with the better method.
Dismissed. Sir, number 17, the state appeal.
My lords, in this case, I represent respondent, my lords.
To come this side. As I appear for the state, Lord's matter relates to payment of gratuity. Lord's 1971, my lords, he was appointed as a daily wager. Then in 1990, my lords, he is regularized. After regularization, my lords, he superannuates in 2013. From the date of regularization till 2013, he is a state government employee. Gratuity has been paid in terms of the state government rules. Now the issue, my lords, is from the date of the appointment as a daily wager till the date of regularization, they are claiming gratuity under the provisions of the Payment of Gratuity Act. Now, my lords, the learned single judge has followed a decision of the Supreme Court, my lords, in Netram Sahu's case, and my lords allowed the petition. Now, my lords, my respectful submission is Netram Sahu's case, a division bench, my lords, of the Supreme Court has referred, the matter has been referred to a full bench, and in respect of similar matters, my lords, Supreme Court has already stayed it. May I just pass on, my lords, the reference order as against Nethuram Sahu's case?
State is yes, but merely because the matter is referred to full bench.
No, my lords, matter is referred to full bench. In Karnataka state government matters, stay has been granted by the Supreme Court also. I'll just pass on that order also. Notes, in fact, may I just pass on these two orders? Notes.
That's referred to larger bench. What is it?
Notes, in para 3, they refer Netram Sahu to larger bench, stating that it is contrary to earlier two-judge bench decision, my lords, of the Supreme Court. And then they also refer to a learned single judge order of this honorable court, where a contrary view was taken, which is in favor of the state. That is also referred to, my lords, in paragraph number 5, where learned single judge decision, my lords, has been referred to of the Karnataka High Court, and matter requires consideration. Then stay has been granted, my lords, in similar matter.
Third learned additional.
Please, my lords.
So assisted by learned additional government service. The challenge in this appeal is directed against the judgment of learned December 2023, whereby learned single judges required the respondents to pay the arrears of gratuity to the petitioner to the extent of rupees 2,40,449 with interest. First of the said amount of gratuity. The petitioner is also directed to pay. Petitioner is also entitled to. The respondents are also directed to pay cost of the 50,000 the petitioner. Cost of the period for which the gratuity is counted and granted includes the period during which the respondent employee rendered their services. How many? Only one?
1%.
Respondent employee rendered the services as daily rated work. Full stop. The question whether the services.
My lords, may I make submission, my lords?
Daily wager before being regularized and given the status of a regular government servant can be reckoned for the purpose of invoking the provisions of the Payment of Gratuity Act 1972. After the age of superannuation retirement, 72 was considered by the Supreme Court in Dansai Sahu versus State of Chhattisgarh and others. In the Brigade 2020, 19 Supreme Court 808 in which the apex court has referred the issue to the larger than full stop. In addition to the work was pointed out by learned additional advocate general with reference to order of the Supreme Court, Honorable Supreme Court passed on 27/3/23 in special leave in assistant executive engineer versus assistant executive engineer CNNL CD Srivastava Iyengar, which was special leave petition in civil regulatory diary number 9156/2023 that in the identical case in the aforesaid special leave petition, the Supreme Court has granted interim stay.
Please, my lords.
Full stop.
Arising-
Aforesaid view, strong prima facie case without the appeal is admitted, the impugned order of impugned judgment and order shall remain state.
Great.
The appeal may be notified for final hearing after final hearing in on 16th June.
Please, grateful.
2020.
Much obliged.
Grateful.
This number 18. Mr. SB Mukana.
Apparently, in this
Contempt petitions are listed. Contempt petition will not survive. Very good. Contempt petition is listed along with the.
I'm the appellant in this case. Week's time may be granted, my lord. The notice is already been issued.
Delay of 40 days is.
40 days.
Delay of 40.
Delay,
Who appeal?
40 days.
Who appeal? Divisional controller. Yes, artist. This is the penalty of dismissal. Yes. So they are served.
Week's time may be granted, my lord. They have not filed any wakalatas.
Who appears for KSR?
The HR Renka or BL Sanjeev is also appear. BL Sanjeev.
The board indicates that all the respondents for the KSRTC and input are served. We did not pick up this court, however, it is not filed. In their two learned furnish copy of this, it appeal along with the civil application.
Much.
Honorable Mr. Sanjeev,
BL Sanjeev.
who normally appears on behalf of the KSR,
Much.
put up on 21st of,
Much.
22nd of January.
So number 19. Ravindranath Tarigaki.
Seeking a week's time, my lord, sir. Seeking a week's time, my lord.
The request of learned petitioner stand out, not week then, it will go to 5th of March.
Grateful, my lords.
This is number 20. So PL Mr. Parameshwaraya DC. Number 20.
20, government is to file reply, some government land is. There's a direction in the last of.
Appearing, sorry, my lord. My lord, this pertains to, my lord, consideration of the representation.
Last time there is an order probably. Not.
I'll file, my lord.
Okay. Reply may be filed before me.
My lord may grant me some time.
Time to file reply is extended. Until the next date, stand over to 27th February.
27th.
Number 21.
Lord, I appear for the
Mr.
petitioner
Kumar
in this case, please, my lord. The petitioner in this case is challenging the order passed by the Director, Department of Mines and Geology, my lord. It is produced at Annexure A, please. It's at page 26, my lord. Wherein the application of both the petitioner and respondent number 5 are rejected. without any proper reasons, my lord. No reason to reject both the applications.
The area is not
Please, my lord.
for the purpose. Is not fit for, is fit for covering.
Lord, can I make one submission, my lord? In this matter, my lord, as against the impugned order, same impugned order, my lord, it's a common order. Respondent number 5 has filed a revision petition before the respondent number 1, my lord, which is pending consideration. Yes, review has been preferred by respondent number 5. It's a common order, basically. So a revision is pending, my lord, that is being deferred in view of the pendency of this writ petition, my lord.
And this is
He also has the remedy of filing a revision.
under Rule
53.
53, my lord.
Under Rule 53.
State government.
Please, my lord,
Let go.
respondent number 1 is
Before
the
the-
authority, my lord.
Revision, my lord, revision, revision.
Revision, my lord.
Depending.
Revision is pending, my lord, filed by respondent number 5.
No, no, revision is filed by respondent number 5. Here also, there is an alternative remedy under Rule 53 because the order is passed by the director, my lord. So there is a revision by way of an alternative remedy under Rule 53 of Karnataka Maritime Concession Rules, my lord.
That revision is already filed by one of the.
That is the respondent number 5, my lord. It is a common
No,
order.
that is independent because in that case, it is for non-specified maritime mineral, my lord. An order was passed by the senior judge on the direction.
No, I will make my submissions, my lord.
Either you also file your revision.
Yes, my lord. It can be decided, my lord. It can't be before the 2 authorities.
Or you wait since it is common order. Simple.
No, my lord, because my lord, my lords may now kindly see page 51, please, my lord. Page 51 of my writ petition. The mineral, my lord, in respect of both the applications by the petitioner and respondent number 5 are for 2 different minerals, my lord. One is for specified minor mineral and another is for non-specified minor mineral. The jurisdictional authority to consider my application is the government as envisaged under, as it existed then under Rule 11, my lord. My application has to be inevitably placed before the government for consideration. Now the revisional authority for my case is the government. So, my lords may now kindly see the order, the page 51, please. My lord.
Remedy is before the state government.
Yes.
You do have the remedy.
No, my lord. No,
There is, my lord. There is because it is an order passed by the director. So director's order can be filed by way of revision before the government, my lord, secretary. That is under Rule 53. In the other case, so far as respondent number 5 is concerned, he has filed his application for non-specified minor mineral against which an order was passed by the senior geologist on the direction of the director. Therefore, we have preferred a revision before the government. Similarly, they also have an opportunity to file a revision before the government because there is an order by the director.
my lords may now kindly see page 26, my lord.
Where is the provision about the specified mineral? Then the, will go to other.
No, my lords may now kindly see the order passed by this honorable court in my writ petition, which is at page 51, please. Lords,
You're trying to argue that since your case is involves specified mineral,
mine is for specified minor mineral.
then revision will not stand 53. Where is that?
No, my lord, yeah. Rule 53 says, of course, my lord, the revision lies with the government. But the direction from this honorable court is to consider my application by the government itself. Lords may now kindly peruse Rule order, which is at page 51, please, my lord. Therefore, revision in respect of non-specified minor will not lie to the government. In view of this order, please. Page 51. Therefore, after hearing so and so, appearing for all the respondents, we dispose of this writ petition by directing the additional chief secretary, Department of Commerce and Industries, and also the chairman of Rule 11 Committee constituted in the Karnataka Minor Mineral Concession was 1994 to convene a meeting of such committee and to take decision on the application of the writ petitioner. The recommendation of the committee shall be forwarded to the state government for necessary action.
Wherever you choose to go, you go. Whichever the remedy is proper in accordance, in your view, you avail that remedy.
No, my lord, what happened is, my lord, the initiation of proceedings by the director itself is opposed to the law, my lord. Which it is opposed to the law, my lord.
Which, by number 5.
Impugned order, my lord. It's
Huh.
a common order.
No, it's
a
an
common order.
order passed by the director, my lord,
Page 26. my lord.
rejecting their application.
His application also. Both the
Both.
applications are rejected. Both the applications are rejected.
I have gone before the state government
Yes,
The common order.
under
I agree.
revision, my lord.
I agree.
The reason why I have gone behind this thing is, before the secretary is, because my order has been passed by the senior magistrate on the direction of the director. So therefore, he has become officious functo. Therefore, I have gone before the government, my lord. Otherwise, I ought to have gone before the director. In this case, the order is by the director. Therefore, a revision lies before the state government, my lord.
It is suo motu inquiry by the Director, Department of Mines and Geology, my lord. My lords may now kindly see the representative, fourth, fifth respondent made a representation, which is at page 96, please, my lord. My lord, the point is this, my lord. May I submit, please, my lord? The petitioner applied for a grant of a quarrying lease in respect of non-specified minor mineral. Whereas the respondent number 5 has filed an application for specified minor, non-specified minor mineral. While getting the matter disposed of, my lords may now kindly see the order passed in his writ petition, please, my lord. There was which is at page 70, please. My lords may kindly peruse page 70, please, my lord. Page 70. This is the, my lord, fifth respondent had filed an application for non-specified minor mineral. My lords, it is called building stone, my lord. The direction, my lord, is the writ petitioner is agreed by his application.
Building stone is right, my lord.
1 minute, please. For mining lease for extraction of ordinary building stone is not considered by the authorities.
Which page?
Chikballapur.
Which page, Mr.?
Page.
Page, it is 72, my lord.
70.
Please,
So that is ordered by the division bench.
division bench, my lord. It is in respect of ordinary building stone, in respect, he had filed 2 applications. He has filed 2 writ petitions.
This also does not indicate that the revision would have been for particular.
Yes, my lord.
No, that was only Mandamus we had sought, my lord.
Does them say that rule 53 will not,
Correct, not apply.
does it say any of the order, either page 51 order or page 72 order?
No,
No, it doesn't.
no.
Then you go under 53. It doesn't say that 53 is outstayed or you have to go. before
Because, my lord, there was a misleading statement by the respondent number 5.
The challenge in this petition is directed against, the challenge in this petition filed under Article 226 of the Constitution is directed against order. This is the date of the.
My lord, the date of the order is, my lords will get it at 28th October 2022.
28 October 2022.
Please, my lord. It is in Kannada, but by inadvertence, it is not typed in the translated copy, my lord.
Thereby the application of petition for grant of co-release in serial number.
Number ಕೊಟ್ಟಿಲ್ಲ sir.
Come to page number 25.
Yes, my lord. 28th October 2022. Adesha
1510.
15/10/2022. but it is dispatched on 28th October. Please.
Whereby the application for grant of pouring lease, serial number 4 of Alapura, PUMM, LAPURA, Alapura Taluka, Chikabula district. Was rejected. What is your application? Two applications.
My lord, two applications were filed by fifth respondent, my lord. One application is filed by me.
Which is your 355?
1 minute, my lord. My application number is,
Page 34, my lord.
it is 380. my
4
lord.
and 355 are filed by them. Petitioner has filed
Page
80 of 12.
My lords will get it at page 35, my lord. My serial number is 380.
380 of 2012.
80 for the extraction of mineral, ornamental mineral.
For ornamental stone.
Into gray granite.
Grey granite.
Full stop. Along with the application of petitioner, the other applications filed by the priority number 3 hearing for
Building
business
stone.
purpose were also rejected.
My lord, but his application is for ordinary building stone. It may kindly be noted, please.
Building stone, my lord.
Building stone, it's a non-specified minor mineral.
Okay.
It's one for building stone.
My application is for non-specified minor mineral,
For
which
regular
is earlier actually.
building stone.
Building.
Please,
stone.
my lord, building stone. Prior to their application, my lord.
Two reasons, two aspects of the matter pursued the court not to entertain the petition. Firstly, the petitioner has remedy under rule 53 of the Karnataka Minor Mineral Conservation Rules 1994, filing revision application for the competent authority to the state government.
Please.
Since the order impugned in this petition, since the aforementioned order impugned in the petition is passed by the director. So rule 53 contemplates that any order which may be passed, that any order, that any person aggrieved by order of competent authority of the rank of the existing director above the rank of the may file the petition within the stipulated time of 90 days. In view of the alternative statutory remedy available from this court to below, and is inclined to entertain the petition by invoking text out in jurisdiction or the Article 226 of the Constitution. Second material aspect is that Respondent 5, prior to Respondent 5 hearing, who has also suffered the same order. Failing with the petitioner hearing, has already filed for revision numbers under rule 53 of the post of. In that view, relegating the petitioner to the said remedy of revision, and without going into merits of the case of the petitioner is not entertained and
Disposed of.
Number 22, to P. Mahesh.
petitioner. Notice is issued.
Notice is issued, my lordship.
Reply is not filed.
Yeah, my lordship. Yeah, earlier, my lordship, my application came to be rejected. I made an revision before the authority, my lordship, wherein they have allowed my revision petition and redelegated to the respondent authority. My lordship, the respondent authority needs to grant the no objection, my lordship, to the land in question. But they are encouraging illegal acquiring, my lordship. They are not granting me who is asking for the legal, my lordship. Already 10 years has
Case of
been.
Mandamus, my lord, an endorsement has been issued, my lord. I'm filing a copy of the endorsement.
Filed.
Please. Also a copy and file.
Reply shall be filed by Nation Government Advocates, 10 over to 20th February.
Serial number 23.
A date may kind of 20th February.
My lord, appearing for the petitioners in this matter, my lord, I'm seeking a 2 weeks accommodation.
Number 24.
My lord,
Yes.
we are
Bob.
for-
For the petition of lords. This is in relation to lords.
Can wait, it is.
My lord, I'm filing
lord.
memo
Appearing for respondent number 1.
to my lord notice the exact situation of the vacancies in the Karnataka State Administrative Tribunal. Sir, where is the note? Yeah. Two petitioners. My lord, as on date, we have 2 vacancies, each in the administrative and on the judicial side. My lord, we have requested for dates.
Administrative side only one.
Two.
Only one.
Two.
No, no. Only one.
One administrative.
Administrative side only one.
Well, I have given it as two.
Lords, there are circuit benches, my lords, or the benches, my lords, at Belgaum and Kalburgi. But however, my lords, total strength of the my lords, the judicial members and the administrative members, my lords, are operated, my lords, under the Bangalore tribunal. Totally, my lords, there are 5 judicial members posts and as well as, my lords, the 5 administrative members. Out of which, my lords, at present, there are 3 judicial members and 3 administrative members. 2 benches, my lords, are not functioning.
My lord, we have sought for convening of the search cum selection committee meeting. My lord, once a date is fixed, my lord, then we can proceed
Yes,
further.
The present petition concerns the appointments to be made. Post of, this is Karnataka elected regulatory government.
No, my lords.
Karnataka
Administrative
State
Tribunal.
Karnataka State Administrative Tribunal.
Tribunal.
Then you have wrongly stated. Karnataka State Administrative Tribunal. Post of the judicial post, judicial vacancy.
Yes,
Of the
ma'am.
filling of the post of the judicial
Member.
members and the administrative members in the Karnataka State Administrative. Today, when the petition comes up for consideration, petition government advocates in local files a memo in which details are given about the existing vacancies and existing vacancies which are to be filled up. It is further stated memo, it is stated further in the memo agenda. And for last paragraph. Last 2 paragraphs. In the aforesaid view, the consideration of the matter and the prayers made in this petition is deferred. Stand over to, we'll say 11th March.
Obliged.
Lords, before that, my lords, may just, my lords, make one submission, my
They have
lords.
said it is under process.
No, my lords. Annexure D, my lords, only one submission, my lords. Annexure D in the petition memorandum at page number, my lords, 56. Please, my lords. In the identical circumstances, my lords, the Honorable Supreme Court, my lords, passed an order stating that, my lords, the existing members, judicial and the administrative members, my lords, would continue to function till, my lords, the new appointments are made and they take the charge. My lords, it clearly says, my lords, not with reference to one member.
Today they have retired.
My lords, that could be, my lords, continued by virtue of the order of the
My
Honorable
lord,
Supreme
we have
Court.
set the process in motion. We are waiting for the
No,
fixing
kindly
of
see,
a
lords,
date
para
for
four, lords.
convening
Pa-
of the meeting.
No, para
But
4, my
once
lords.
that happens,
Sir, no, today there is no existing judicial.
My lords, the para 4, my lords, as on the date, my lords, it was there.
May I submit, my lords?
As on the date of filing of the petition, my lords, they were there, my lords, they were functioning.
Cropped up, similar thing was cropped up in Gujarat also. Where
I
the
have produced, my lords, I have produced.
Retired wanted on the basis of this order to continue.
a lot, but they have not come forward.
There we did it.
Ultimately, my lords, so far as the members of the bar, my lords, is concerned. My lord, we want the, my lords, the benches to function.
After unreasonable time, it is not done.
Obliged.
11th of March, my lords.
11th.
Obliged.
Grateful.
25 to 27 are urgent. Number 28. Surely.
Serial number 28 to 30, not, these are all simple matter seeking writ of mandamus, not seeking a direction against the respondent number 3
to consider the application filed by the petitioner for grant of quarrying lease, my lord. These applications filed in the year 2015 and 14 respectively. But similar matters, my lord, the lordship are
The
disposed
lot
of
has disposed of.
on
similar-
6th of January. WP number 29174.
Within how much time? 12 weeks
8 weeks granted in similar matter.
without going into mail.
Yes, obligement.
28, 29, 30, all are similar.
28, 29, 30.
Please.
All are disposed. 31 is also disposed.
Still number 32, Ashok B. Mulage. 32.
My lords, I am appearing on the petitioner matters. My lords, I am representing the petitioner.
Yes. Requesting for
Please, my lords, I have sought for the, my lords,
your voice doesn't reach.
my lords, as far as the kindly annexure K at page number 62 is the order passed by the respondent number 2,
My lord,
directing
Need
the
some time
petitioner
in this
company
matter, my lord.
to stop.
Other side wants time.
My
will grant.
my lords, once,
Learn it.
my lords, serious consequences, my lords, the hazardous material is there in the factory premises since last nearly about 1 year.
Your voice is not clearly
Well,
reaching,
sir.
but other sides wants time will grant short order accommodation. Stand over to when? 3rd February?
Very good.
Hazardous material is there, my lords, in the premise January
Still number 33.
2024. The premises is closed by the respondents.
It is already adjourned to 3rd February.
Sir, adjourned to 3rd February. Still number 33. The KV
In the
Satish.
last occasion, I have already filed an objection. According to that, the government is to be comply the order. But still, they have not.
We have filed her compliance report, my lords.
I filed an objection, sir.
Substantial compliance. The only issue is, my lords, the 1 month contemplation of 1 month. I will explain, my lords, why that 1 month delay in initiating suo motu proceedings were there. There was code of conduct at that point of time. That is one thing which is code of conduct, my lords. And Conduct prevents you to implement the court. that's the code of conduct, my lords, the officers were posted elsewhere. They were not in their own positions, my lords. This is all I have. Otherwise, my lords, I have filed my affidavit which says that from the date of their filing and representation, within 2 months, we have taken Oh, a decision. Proceedings are initiated. Yes, my lords, it's always, it's almost
Following-
concluded also. Following were the directions.
On submission, I filed an entire objections that our objections, Your Honor. Detailed objection, whatever the cause of action was taken, then what are the raised the objections. Within this time, they have complied it, Your Honor. But unfortunately, they have not complied it. Only the code is up to 2000, I have got the ownership and RTC was in my name. After the changing of the computer pani, my name was not entered in the computer pani. In this regard, 3 to 4 times I approached this honorable court. Then the trial court is clearly stated to that they comply the order and directed to change the pani in the name of complainant, Your Honor. Still, they have not changed, Your Honor. And also, I produced the documents, Your Honor.
Matter is reserved before the special DC for orders, my lords. Matter is reserved before the special DC for orders pursuant to the orders passed. by-
One week time, I will ready to accept. Hello, because I filed it, I filed it. Detailed objection is to be filed, Your Honor.
What?
In the,
They initiated the proceedings, which is the only direction. The name is entered. My lords, no, my lords. Why? My lords, their direction was, the Tashildar has to initiate suo motu.
not only,
proceedings. If not initiated.
Please, my lords, he has to initiate suo motu proceedings
within 1 month. We have initiated it and the matters are reserved before the special DC for orders. Everything, the proceedings are completed.
On submission, Lordship.
Only the 1 month, my lord, so therefore there is no willful disobedience.
Are you inquiring again, are you inquiring about validity of the grant in this case?
Please, my lords, 136.
No, one submission, Your Honor. Because the page number 18 of my contempt petition.
That
Kindly
is
see the para number 5 of this writ petition, Your Honor. Kindly be see the para number 5 of my, what is stated in the meanwhile in the petitioner approaches the Tahsildar seeking continuation of his name. The computer is spawning. The Tahsildar shall consider the claim of the petitioner for continuation of his name in the computerized spawning. The Tahsildar shall not decline to consider the claim of the petitioner on the ground that no grant was made in favor of the petitioner. If the Tahsildar is of such opinion, then he have moved the competent authority to invoke the suo motu under section 136 of 3 of the Act, which is also akin to the orders of passed by this court in writ petition number 00/2013. If such action is to be initiated, it shall be initiated within a period of 1 month from the date when which petitioner approaches the Tahsildar seeking revenue entries. If suo motu proceedings are not initiated, suo motu proceedings is not initiated within such period, the Tahsildar shall proceed to enter the name of the petitioner in the land records and in the computer spawning without waiting any further. That is a direction by shall is used.
Sir, for that reason itself, the Tahsildar has requested the Special Deputy Commissioner to initiate appropriate proceedings under section 136(3) of KLR Act.
In the earlier 2013, that was exhausted, Lordship.
Now, if they have initiated that, you have the liberty to challenge it, sir.
Because is not.
Because the order is clear. Either, see, Tahsildar does not have the power to say whether the grant is genuine or not. Once your name was found in the regular RTC, handwritten RTCs,
Yes,
after computerization, the Tahsildar is bound to include your name.
Yes, Your Honor.
But Tahsildar is having all the powers to take up the matter with the concerned Deputy Commissioner for proceedings under section 136(3),
yes,
which he has done according to the government.
That's why I filed an objection. Kindly see my objection statement.
So this is a contempt matter. This is not a writ appeal.
No, it is not a writ appeal, Your Honor, because in the 1 month, intentionally they have dragged the matter, Your Honor. In the last occasion,
that alone can't be a ground, sir.
Allah, that in the last occasion, they have to taken the time to comply the order of disarm court, Your Honor. But this time they have filed any inquiry before the Deputy Commissioner. This is the 4th time the inquiry conducted by the Deputy Commissioner.
Going over the direction in the order dated 18th April 24, passed by learned single judge. Extracting from paragraph 5 and 4th paragraph 5. As per the directions, the Tahsildar was
There are the 4 petitions, Lordship.
As per the directions, the competent authority was permitted to invoke the suo motu powers under section 136(3) of the Karnataka Land Revenue Act in relation to the claim of the petitioner for entering his name in the computerized PAHANI, PHANI. It was provided that if the suo motu proceedings are not initiated within 1 year,
1 month.
1 month from the date the petitioner approached the Tahsildar seeking the revenue entries, the name of the petitioner shall be entered in the computerized fund. Full stop. Today, when the contempt petition come up for consideration, the fact is admitted. The fact is admitted that the competent authority has already initiated the suo motu proceedings. as contemplated in the aforesaid direction. Full stop. Once the suo motu proceedings are initiated, comma, in the view of the court, comma, the contempt proceeding would not survive as the directions are substantially complied with, and that the authority has acted in the direction of the compliance. Full stop. It was sought to be submitted, paragraph, by learned advocate Mr. So and so, that the suo motu proceedings were initiated after expiry of period of 1 year.
That is not one ground, Your Honor. In the judgment is also 2013 was also suo motu 136/3 was taken by the deputy commissioner, Tahsildar and deputy commissioner. In the judgment para 4 of the judgment is clearly stated 2013 was also already that order was quashed by the Salma Court. Already was taken by the deputy commissioner, Your Honor.
And he further relied on the order passed by this court in writ petition number 144-908-909 of 2013. Full stop. He submitted that since there was a delay in initiating the suo motu proceedings, comma, the petitioner automatically became entitled to get his name entered in the land records, comma. Responding to the above aspect, from a learned additional advocate, government advocate, Srimati Pramodini Kishan submitted that mere delay of few days in initiating the suo motu proceedings would not automatically invest the petitioner with a right to have his name entered in the revenue records. It was further submitted by her that it was due to the
Code of conduct.
Code of conduct prevalent or in operation in view of the
Elections.
parliamentary election,
Legis.
parliamentary elections, that the officers could not attend to the immediate compliance of the order, full stop. Whatever may be the cause, no, don't write it, full stop. The explanation is plausible and liable to be accepted. Paragraph. Even otherwise, comma, once the suo motu proceedings are initiated, comma, the contempt is purged and the further rights would accrue for the petitioner only upon completion of, only upon the outcome of the proceedings which are initiated.
The time may be fixed to the deputy commissioner because it is in 25 years. We are struggling for the Pani for 25 years, Lordship.
Contempt proceedings are closed, not surviving, as the orders are complied with. Learned advocates at this stage, learned petitioner, paragraph, at this stage requested that the time limit may be fixed since 35 years.
Within a week, within 15 days to be completed, because already argument was canvassed by both the petitioners, Your Honor, but still they have not kept quiet in the orders, Lordship, because the Salma Court is directed to speedy trial by the deputy commissioner. Otherwise, pending going.
Fixing the time limit for completion of the suo motu proceedings is not within the domain of the contempt jurisdiction. However, it is expected that the authority shall act expeditiously to decide the thing.
Obliged.
Done?
This is number 34. So why by one?
This is the matter where the FIR came to be stayed, and despite that, the charge sheet was filed. It is for them to respond.
Now we can say that charge sheet was filed on 26/11/23. Order
Charge
was
sheet
passed
was
and
put up on 28/11, my lords. The charge sheet is dated 26/11.
26/11, 28/11.
It was put up on. I need a copy of.
Received the intimation subsequently, not after filing of the charge sheet.
Because I may be permitted to file a list of dates in there.
So before receipt of interim order charge sheet.
Yes, Lord. What happened, Lord, when interim order was passed, Lord, it was not within our knowledge.
That is what this.
And there was an order by the magistrate's court, Lord, and it was accepted. Subsequently, Lord, after filing of charge sheet, after after a month, Lord, I received information regarding the interim order on 14/12. I had filed charge sheet on 26/11. So almost 20
Maybe
days.
I may be permitted to make a small submission, my lords. At page number 67, again, they have not responded to this particular factor. Page number 67. My lords, the interim order was intimated to the accused on 10/11/2023 through WhatsApp, through the same number through which the police notice was issued. There is no explanation to this effect. And my
This
lords,
was a
it is.
WhatsApp message. It was a WhatsApp message,
And-
Lord, which every 24 hours, Lord, it gets automatically deleted because of this.
That cannot be a ground, my lords. I mean, to be really honest, my lords, messages cannot be deleted automatically.
Today, there's some criminal cases pending. Or what is pending before learn a single?
My lords, the 482 petition.
482 petition is pending. Lord.
Interim order was passed
Pending.
on 10/11, my lords. It is unbelievable that they get the information on 14/12 from the HCGP's office. And HCGP has taken notice on
No,
10/11.
it was from the High Court that.
No, it doesn't work that way. It is highly improbable, my lords, that order dated 10/11 is communicated on in the month of December. And there is no
But
explanation.
here, my Lord, it says delivered, but it doesn't say seen.
That is, should I come and see the matter, my lords? I don't understand.
It is in respect of order dated 10th November 23, passed by learned single judge. In the proceedings of writ petition number 2504 of 2023, which is an interim order, comma that the contempt of court is alleged. Full stop. The order brought under the paragraph contempt jurisdiction. The aforesaid order as brought under the contempt jurisdiction reads as under. Then quote the bracketed part, enter page 20. This is the. As per the interim order. Further investigation. Pursuant to FIR bearing crime number 0412 of 2023 dated 12/9/23, registered by respondent 1 for the alleged offences under section 504 and 506 of the Indian Penal Code 1860. Came to be stayed. Full stop. The allegation in this paragraph. Contempt petition is that notwithstanding the aforesaid interim stay granted against the further investigation, comma, the respondent police investigating authority, respondent police authorities filed charge sheet on 26/11/23 and thereby committed breach of the order.
My lords, they filed it on 28/11, put up on 28.
28/11/20. Full stop. In response to notice, comma, when the petition comes up for consideration today, comma, compliance affidavit dated 9/1/25. 8/1/25. Affirmed by one Yogesh LL, son of Linga Murthy, working as, stated to be working as police sub-inspector, HSR Layout Police Station, Bengaluru City, is filed in which it is stated that he was in charge of the investigation. Pursuant to the aforementioned FIR, it is further stated that the investigation was completed on 26/11/23. And that the order of stay dated 28/11/23 was not
Stayed,
known to him until 14/12/2023. It was only on 14/12/23, as per the case of the respondent, that the order was communicated, and therefore, without having knowledge of the said interim order, the charge sheet was filed. Full stop. As against above, comma, the submission of learned advocate to the petitioner is that the police officer was sent what?
through WhatsApp.
Sent a WhatsApp message, full stop, which the screenshot of which is produced on record of the petition. Full stop. About the above, the explanation is coming forth in the affidavit in reply, as it is stated that the said message was not seen by the officer, and the message got deleted every 24 hours. Full stop. The explanation is plausible, and the court is inclined to accept the same. Full stop.
My lords, I may make
Totally-
a submission.
Paragraph, in the totality of the circumstance, facts and circumstances obtaining, this petition is disposed of, this contempt petition is not entertained and disposed of by requesting learned single judge to dispose of the main, what is the special criminal application?
Yes, criminal petition under section 482 seeking for quashing.
Special criminal, what is the nomenclature? Special criminal application.
Criminal petition.
Yes, my lords.
Criminal
WP
petition.
number
Yeah.
25042.
Then it is criminal petition. Criminal petition?
No, it's a writ petition under section 482 read with section
Is it writ
220.
petition? Writ petition.
My lords, one submission.
250.
There is nothing, I mean, before it is disposed of, my lords,
Writ
there is
petition.
nothing on record to show why was there delay of communication when HCGP
Under section
has received notice.
482 of the Code of Criminal
This,
Procedure,
my lords, this is a bit serious.
within a period of 6 weeks. 6 weeks, 4 days.
But
As expeditiously as possible. In which the party shall cooperate.
Yes, my lords, but my lords, this is a bit serious. It cannot be held in this manner of
It is.
1412, my lords. They have nothing on record to show as to how they received the communication. They have not produced anything.
The register is directed to list the said writ petition number so and so before learn a single judge on 20th.
Great.
Date is given.
No, no date has been. But my lords, this is.
Unless the date is given by learn a single judge.
No, there is no date.
So we can't impinge upon the jurisdiction. So unless the date is given,
My lords?
unless the date is specified by learned.
Yeah, fair. My lords, but then at the end of the day, I know it's done, my lords, but this is very serious, my lords. Insofar as there is nothing on record to show that they received the order after 1 month, my lords, then the point of getting a stay itself would be futile.
Communicated from the court.
My lords, and HCGP has received notice on the same day. At least there should have been a report from the HCGP's office that it was sent.
But in every matter, court can't be a doubting Thomas.
My lords, I understand, my lords, but then this is very serious insofar as it is not some layman who is doing this, my lords. It's the investigating officer. And my lords, it has to be in that light, my lords. That's the only reason why I'm pushing.
So in light of the facts we have passed. No,
Great.
Yes, next.
Number 35, Sushankar C.
In this
Violation
matter-
of the orders passed by this honorable court, if your lordships would recall, my lord, the learned AG had appeared. First, they said, my lord, review petition is filed. My lord, then that review petition, my lord, they withdrew. Then your lordships granted them time, my lord, to approach the honorable Supreme Court. There is a clear direction, my lord, to enter the name mutation entry. Your lordship said it's my lord, then your lordship may kindly see, they went to the honorable Supreme Court.
That's
and
the matter
order
is
passed
sub
by the
judice, my
Supreme-
lords.
Your lordship may kindly see this.
Your Lordship may kindly see that order page. My lord, there and your Lordship may also, I may just pass on this to show them the prayer. They had specifically sought stay of the contempt proceedings. Ninde is appeal SLP. My lord, here if your Lordship sees in their SLP, my lord, the Honorable Supreme Court has protected our possession. In fact, in one more contempt petition, my lord, where there was a clear direction by this Honorable Court not to disturb my possession, my lord, the contempt was filed. My lord, this matter, my lord, for compliance affidavit from on 23/4/24, on 16/7/24, on 21/8/24, 28/8/24, 4/9/24, 9/9, 19/9. My lord, it has come up before almost all the benches of this Honorable Court, my lord, where they've been directed to comply. If your Lordship recalls, my lord, your Lordship had said to enter the name, to mutate the name, and that could be subject to result.
Lords, the
My lord,
matter is
and the
sub
prayer, your Lordship may kindly see that prayer. The prayer in the SLP was that stay the contempt proceeding. I've just given that, my lord, your Lordship.
Today,
Lords, let them make it.
your possession is protected by Supreme.
Yes, yes.
No.
Let
my lord,
them, if,
my prayer is with regard to entering my name in the mutation. That
Lords,
your Lordship had said, my lord, if your Lordships recall, your Lordship had said that when we said that it could be subject to result, your Lordship had said, my lord, it's a fair ask by them that mutation entry could have been done.
When the Supreme Court protects somebody's possession, it is much more than mutation entry.
No, true, my lord. But mutation entry, they are not doing, my lord. There is my lord, what has happened is, this Honorable Court in the writ appeal, my lord, one direction was to, my lord, protect my position. In the other thing, it was there. My lord, let them comply, my lord.
Lords,
This is,
my lords,
my lord,
their
what I'm
matter is
submitting
sub
this.
judice,
My
my
lord,
lords.
the Supreme Court has refused to stay either the order passed by this Honorable Court or to even stay the contempt
Lords,
proceeding.
let them
Nothing
make
has
an
been done.
application before the Honorable Supreme Court, my lords. Let them make for the entry
Why
of
should not?
Kata.
This
Lords,
is
the
unheard
matter
of.
is
Lord.
sub
Why should,
judice.
my lord,
Matter
in
is,
their thing, I should ask for a prayer there in their SLP, my lord. Unheard of, my lord.
Lords, notice
In
has
fact,
been
the
issued.
petition
That
also,
means
my lord,
there's
they
some
were-
prima facie, there's a case that is made out on merits. Notice is issued and the matter is sub judice.
My lord, there is, my lord, in fact, the Honorable Supreme Court, as your Lordship saw, my lord, in their SLP, my lord, how much of their case has been accepted by the Supreme Court, your Lordship should be aware, my lord, where my lord, this is also a little unheard of, where, my lord, in their SLP, my lord, the Honorable Supreme Court gives me the relief, my lord, accepting what your Lordships have said in the division bench. In fact, in one more contempt, my lord, where we should not be disturbed when we have filed a contempt.
Today, the entry stands in whose name?
Government. That's why, my lord. In fact, your
Possession
Lordship
is
said that,
there.
my lord, what all that I'm saying is, let them enter our name subject to result of the SLP, my lord. That can be done.
No, that can be an endorsement in the end.
Yes, my lord. That's all I'm asking for. Let that endorsement be given, my lord.
My lords, the matter is pending before the Honorable Supreme Court
I-
and they themselves, my lords, they have also filed the SLP, my lords. They have not
My lord,
obtained
your
any
Lordship
order.
had specifically said either get an interim order from the Supreme Court or enter the name. Your Lordship said very clearly told the AG.
You take instruction.
Obliged.
If you say to the, tell to this court that you will insert endorsement in the entry that this entry shall be subject to the final outcome of.
Yes, ma'am. That's all, my lord, I'm asking.
So I'll take
In fact, my lord,
instructions.
Honorable,
We as a contempt court will not be venturing to pass such direction.
So I'll take instructions. on
Take
it.
it.
my lord, because if your Lordship sees,
And
my
that
lord,
is,
this
that is.
Honorable Supreme Court has passed on 22/11/24. Your Lordship said either get an interim order of stay or enter their names.
Even if Mr. Counsel, they doesn't agree for that, it will mean that.
My lord, no, my lord, but under the contempt jurisdiction, my lord, now since they don't have it, my lord, specifically, there's no interim order, my lord. When there is an order by this honorable division bench, not of the single judge, my lord, division bench order very clearly directing.
It's fine.
I'll-
Then we'll take it.
Lord, the short date, my lord, before the vacation, your
Well-
Lordship gave a short date only because of this.
Now there is Supreme Court order, so long.
After the Supreme Court.
Last date, my
this
lords,
matter
it was
did not-
listed
my
on
lord, it
9/12.
did not reach that day.
28 January.
Please,
Obliged.
oblige.
You are already speaking.
Yeah, I'm asking because there's been an error with the party in person committee issued report. On 28/11/24, I attended the party in person committee meeting. Right in my presence, they dictate the report indicating that I can represent myself in front of the honorable court and the reinstated Form C. But then just a few days back on 6/1, I'm told again by the WS scrutiny branch that they have issued a report withdrawing the Form C. I request the Honorable Chief Court to reinstate the Form C and investigate the matter. And I need about.
I don't have why the appeal will go disqualified. The same matter. So that matter is to be posted before, already posted, must have been posted.
It has to be listed for hearing so that the respondent can give a response about the consent letter, Your Honor. The respondent, Your Honor, the Honorable Court has issued orders for them to give the consent letter within 6 months. The due date was 14/12/2024, Your Honor. I'm yet to receive the consent letter, and getting this WA listed will get the respondent to answer the Honorable
The
Court.
committee and the rules will take this. We have no powers.
About
State and
the urgency for the orders, Your Honor.
we can't help that. If you are disqualified to address the court, you stand disqualified. You have a remedy. I have no power to recall the order itself.
But that is erroneously given because I have already represented myself on several cases.
Take out your remedy, whatever. We don't know what remedy you have, but you might have remedy.
Your Honor, the legal agreement that has been breached is Patent Cooperation Treaty, and the PCT preamble has provisions that says contribution for progress of science and technology. Now, this is the very agreement that has been breached, and getting these interim relief orders is going to allow me to establish Science and Technology Financing Bank, STF Bank, which is going to invest in scientific and technological progress in the country to build the necessary technology and technical competence to investigate, tag the Your Honor.
Mr. Is your matter listed today?
No.
Then you can't have an audience over here.
That's right.
If your form is rejected, there is a separate remedy for it. You need to work it out. You cannot make a submission before this court in this particular manner.
What would be the forum, Your Honor? It will be
That you
listed
find
again?
out. Okay, we are not here to educate you, and you will be disrupting the court proceedings otherwise. Yes, call the matter.
We don't have any advisory jurisdiction. You take out your remedy, yes. Go before the same, several passport.
Passover matters. Bill number 1.
Notice returnable.
Hence, you are ready.
18th. Notice on the 3rd March. Earlier, all like 18th February, 17th February.
Not applies the order of this honorable court, my lordship, in releasing the amount, it is, payment is made to some third party is.
17th February.
Bill number 2. To Vasant Kumar HT.
Direction to consult the representation. There is allotment of site. You applied? Yes, ma'am. Then there is no time limit. The direction which is brought under this contempt petition for their alleged non-compliance reads as under page 8 of the order. Any of the above petition is disposed of. वहाँ से लेके eviction removal, 2 paragraphs, extending to page 9. Also, the learned advocate for the petitioner stated that in pursuant to the said directions, the petitioner is already applied under section 38 capital D of the Act to the competent authority. The grievance is that the competent authority is not decided and no decision is communication, no decision communicated. Full stop. In this regard, it is to be observed that the directions of Learned Single Judge quoted herein above do not contemplate any time limit for decision to be taken by the competent authority. In that view, at this stage, it is not possible to conclude that that any of the respondents have committed contempt of court, much less willful contempt. So therefore, the contempt petition is not maintainable at this stage. However,
Direction to consider appeal within 3
Our-
months. Para 3 of the last paragraph kindly be changed. To
time limit
consider
is there.
representation within 3 months.
That is your application.
Yes, my lord. As per the directions, I made representation, my lord.
However,
The endorsement
however,
will
at the
be
same
issued.
time, the directions of the court should not go uncomplied with. Full stop. It is therefore provided that competent authority respondent shall take a decision upon the application of the petitioner already made as stated by the petitioner and render a decision to communicate the same to the petitioner within 8 weeks from today, failing which the authority concerned shall be exposed to the contempt jurisdiction.
Seal number 4, Mr. Ramesh KR.
D is the order passed by single judge of the Honorable Court. Lord, they have not completed the order passed by. single
Notice
judge.
returnable on 19th February.
Problem.
So 230 matters, seal number 80. The Narsim Rajesh case.
Krishna. Delay in contempt matter. It was posted yesterday, section 20, leave it to the court. I'll leave it to the court.
Leave it. The order was
Sent
passed,
notice.
the
on
order
6th
which
Jan.
is, the order in respect of it, the jurisdiction of contempt of court is invoked. Contempt of court 1971 is invoked, was passed by a single judge on 5th September 2022. It contained the direction on the respondents to consider the representation of the petitioner within 6 weeks from the date of receipt of the certified copy of the order. Full stop. Learned advocate, Miss so and so for the petitioner in course of her submission submitted that the copy of the order was served on the authority concerned immediately after passing of the order. Paragraph, section 20 of the Contempt of Court Act 1917 reads as under quote the contempt. Under the aforesaid provision, the contempt proceedings are required to be filed within one year the date when cause. What is the language? Yes. Within 1 year from the date on which the contempt is alleged to have been committed. In the present case paragraph, the period would start from the date when the receipt of the certified copy of the order. Post of 2 years have passed since the date when the petitioner, when the contempt was liable to be alleged. Full stop. In view of the bar of section paragraph 20, this contempt petition is in view of the embargo contained in section 20. This contempt petition is barred, accordingly dismissed. Barred in law, accordingly it is dismissed.
81, I request a week's time. The matter where, my lord, the industry's consent was refused.
Pardon?
Consent was withdrawn, my lord, for fish cutting unit. I request a week's time. Not- This matter was argued, my lord, twice.
I only would say that that's in a week's time, no purpose would be met.
No, no,
Because
I'm not, I have to argue on merits, my lord, not put my.
if they have dismantled and sold the machinery which they're using for fish cutting,
That is second unit will not be unit, not correct. It's manual cutting, my lord. Manual fish cutting unit. Where you have employed about 70 women.
This is the green tribunal matter.
No, it's not a green table.
yes, it is.
Not correct, my lord. My lord, he cannot mislead the court, my lord. Very sorry, my lord. I'm asking time, a week's time may be granted. That this was argued, my lord was supposed to refer the matter for green table. In fact, after hearing me, my lord was urgent. Not a green table. Consent has been withdrawn. If it is closer order under Water Act, my lord, it has to go to the NGT. NGT is in the direction, but this order now under impugnment is not a NGT appellate jurisdiction. Lord, one more thing, Lord. In state of Karnataka, Lord, so far the state government has not constituted the NG appellate authority under Water and Air Act.
That is beyond.
Therefore, Lord, we are forced to come here. Is a consent withdrawal order. Consent has been granted and has been withdrawn without notice to me. May I request a week's time, Lord?
That's my habit after 1 month only then.
I request a week's time.
That's my habit after 1 week only. Why 1 week? There's
Not
no.
for him, same, Lord,
No, I'm.
very sorry, Lord, this is not correct. I'm asking one, I'm asking a request, a week's time.
But there is no order passed by the NGT. Which
But that is, Lord, that is on the basis of the fact that, Lord, the earlier notification of CRZ where 100 meters were fixed. Now that has been amended and it is 50 meter. My activity is beyond 50 meter. There is no prohibition. They are misleading it in this court, honorable court, earlier also. Very sorry, Lord, he is representing state board.
Nevertheless, this order will operate on.
He's operating. I'm not operating now because of this order.
You have to go before the tribunal. and
No,
point
but
out.
that's not.
No, my lords, insofar as a consent withdrawal, my lords, they had to go before the appellate authority, my lords, which is not sitting.
It's not constituted, my lord. My lord has directed as in other matters.
It is not.
My lord has sought response from the state government regarding appointment of the authority under the Water and Air Act.
You really don't need the speaker. Yes.
It's not constituted, my lords. I was given to understand that the process is going on. In any event, my lords, the jurisdiction is not in question. But my lords, the issue which is involved, if my lords, my friend wants to argue, my lords, senior friend wants to
This
argue.
is the order you produced.
Yes, yes, this is the order I produced whereby the industry itself goes on to say at paragraph number 3.
Machines are sold.
No, this is not. Those machines are unit 2. Those machines are part of, there are 2 units, my lord. Those machines of unit 2. I will just make submission, my lord. So far as this petition is concerned, unit 1. Where, my lord, I am manually undertaking fish cutting process, where 70 women laborers have been employed. There is no machinery there. And it is beyond, my lord, prohibited zone. On the ground, my lord, my industry comes within 100 meters, they have withdrawn the order. Illegally, my lord. And their own report says, my lord, I am not within the prohibited zone.
How do we know that this part of your factory is?
Not their own report, my lord. I am not reading anything other than. No, kindly have it next week, my lord. A short date may be given, please. I request, my lord. Twice, thrice, my lord. He is a state, my lord. My lord, difficulties for me, my lord. Kindly have it next week, my lord. My lord has heard this matter, my lord, 3 to 4 occasions.
20th.
God bless.
So number 36. So Pawan Chandra Shetty. Number 36.
That's this matter, my lords,
partial of the order has been complied, my lords. There was 329 mismatch of the revenue entries, that is to with respect to extent, and thereafter PODI had to be considered done. Lords, now we have, it's in colloquial language, my lords, 329 has been rectified and sent for approval to the AC. It's in vernacular language. The huge extent, my lords.
What is the direction?
That's the direction is
From turning page number 30, my lord.
page 8 onwards.
Bottom paragraph. Body and Durst.
PODI and Durasti, and
It is done.
let's, next paragraph is column number 3 and 9, which is
Once more.
discrepancy there. That has been rectified, my lords, and we have sent it to the Assistant Commissioner.
A specific order, my lord, with respect to after initiating the proceedings under 136, subclause 3, my lord. Anyhow, my lord, state has partly complied. I will go through the same, my lord, then I will come back. They have partly complied according to their statement. Now they have served the copy to me. I will go through once, then I will come back. So what about Body and Durst?
Lords, after this, it has to happen, my lords. This process was the initial process. This will have to be approved by the Assistant Commissioner, and then thereafter PODI and Durasti. The Tashildar has done the discrepancies, removed the discrepancy, and is forwarded it to the Assistant Commissioner.
We may grant 8 weeks time and dispose of the.
Yes.
They will let it be pending. Because the defense and many other authorities are, my lord, beneficiary from the state to get the land. So that, my lord, it is pending, my lord, the authorities will be. It is in paragraph 8 and 9 of the, it is in paragraph 8 and 9 of the order of law on a single judge, dated 11th October 23 in the writ petition number 3704 of 22, that the directions are contained in 2 folds. These 8 paragraphs are 8 directions are reproduced here under the court paragraph 8 and 9. Full stop. When the petition came up for consideration today, learned additional government advocate Srimati Mutation stated that the directions in paragraph 9 are substantially and fully complied with, inasmuch as the discrepancy in column number 3 and 9 of the revenue record about the mentioning the land
Extent.
has been rectified by the Tahsildar, and the issue of approval thereof is pending before the assessed commissioner. It was stated that after this exercise is over, which is already acted upon, the directions in first part will be complied with, which are with regard to conducting of and concluding the Body and Durasti within stipulated time. Full stop. The court finds that the respondents have already taken steps in the direction of compliance with the directions of the court, and that the directions are in part complied with. Full stop. Learned advocate for the petitioners, Mr. So-and-so wanted time to take instructions. 10 over to 10th March. So by that time you do whatever.
Number 37.
Lord, I'm filing.
My lord.
My lord, I'm filing my memo of compliance,
Which matter?
37.
47.
This matter may be
My,
decided on 5/2/2024. We've complied entirely with.
my, can I speak, my lord? This honorable court passed the order on November 24, and this office is not complying the order. And they mentioned that center don't have the power to create the post, all the things. As per the due respect, I can submit that bylaws of the copy of the bylaws, which has the power of the center. Council can create the post.
May I be permitted to explain compliance? My lord,
All
kindly
the,
see the.
first of all, can brief my issues in the just 2 minutes, sir. My case was the regularization case, not the fresh appointment. So the audit paras was irregularly, because audit paras very clearly saying is the fresh appointment for CC rule 2016. My case was a regularization which is approved by the Government of India, DST, as mentioned in the attach that paper. 1 second, sir. Page number 69. You can see that the regulation committee on the regulation of the temporary post support staff of the Center Liquid Crystal Research.
The impugned order is at page 13, my lord.
Have you produced the order? Passed
Lord,
on.
the order is in R1, page number 1. It's dated 5/2/2024.
No, that date is not there.
5/2/2024.
5/2. Is there?
That we have considered the representations made by the
5/2 code. It is there.
in R1. It's 5/2.
Yes.
He has also filed this order itself. He
Yeah,
has
I
also
filed-
filed this order as Annexure B. My submission in this regard is that this may not be the appropriate petition to file if he has a grievance with that order. He's filed it by way of contempt, as though he has a grievance with the order. We have complied with the learned single judge's order, which is at page 13. May I take your
But
lordship's?
that office has issued the letter to me mentioning that we cannot, the center don't have the power to create the post, all the thing, but as per the bylaws, the center has, the government council has the power to create the post. And second thing, my case was not the fresh appointment. It's very clear, or the regularization is approved by the Government of India.
My lord, may I take you to para 3 and 4 of the learned single judge's order at page 15?
Because it's very clear on the order also, we can give the whatever repetition I given to the office, they have to consider on that. And bylaws of the center is very clearly mentioned, center council has the power to create the post as well as appoint the persons, because it's autonomous institution. Under FR 27, which is mentioned that initially pay fix cannot be reduced. Once fixation was done by the competent authority in excess of the discretion of the West in the under FR 27, that authority was not competent under the law to reduce the initial pay originally fixed, even when such pay was based on the sum data which is subsequently turned to the incorrect.
In the order, he mentioned FR 27, he cannot create the post, which is reversing both the cases.
So the audit office again says no.
No, audit objection very clearly mentioned that for that CC rule 2016 is applicable only fresh appointment, not for the regularization. My case was the regularization, which is, and DST internal audit report also can sees that this is very clearly mentioning that my case
In merits,
is
we can't-
eligible for the pay scale.
We can't go on merits, go in merits.
The internal,
In merits, we can't go in contempt jurisdiction.
no, sir, merit means like,
That we know.
because they not follow the court order. So we have to, there is a, as part of the things, we have to file it out, sir. Because we need the natural justice. So we are requesting here, I am requesting here because that's why I come on the person. And because center has the full power, so council has the power to create the post, FR 127. Can I submit some papers? So that can be bylaws copies there, so you can.
Who appears for, you are appearing for audit department?
I'm appearing, no, my lord, not for the auditor. I appear for the employer, Center for CNS.
I am the employer
What are
and
the
petition,
director?
employer cum petitioner, I am here.
You are number 4.
My lord, he's
Who is number 4?
just made accused 1 and 2 as
It's
the
the-
employer. I'm appearing for both accused 1 and 2, who are one and the same. He's not made the DGA, the audit department.
No,
part.
the previous order, DGS is this, Velil mentioned that CG has no role and CAG always says we are giving the suggestion, is not implementation, is up to the institution.
1 and 2 to consider representation and pass in accordance with law. Expression of entry pay.
And my lord, in para 5 also, in consultation. Lord, may I make a submission? We've complied entirely with the orders in paras 3, 4, and 5 of the learned single judge's order. This is not the right remedy if he has a grievance with the considered
No, he's-
decision we have taken.
They not compile the order copy and orders which is single judge bench given that because they not consider my representation Q and R. In which very clearly I mentioned that under these rules and these things, I'm eligible for that because my case is the fresh, not the fresh appointment. And CAG also submitted the affidavit. This CCA rule 2016 is applicable only for the fresh appointment.
If it is palpably wrong, then
My lord, I will point out on merits also
what
why.
says that decided in accordance with law? What is?
In accordance with the law, my lord, then if we get on merits also, FR 27, which he has also filed, may I permit? It is
Yes,
at page number 82. Specifically on the basis of FR 27, we have said that we cannot grant this to him after taking consultation with the DGA.
no, because CAG.
Can I be permitted to answer? My lord, in respect of FR 27, sorry, my lord, it's at page number 79, Fundamental Rule 27. The scope of Fundamental Rule 27, in terms of the provisions of FR 27, subject to any general or special orders that may be made by the president in this behalf, an authority may grant a premature increment to a government servant
on a time scale of pay if it has power to create a post, permanent or temporary, in the same cadre on the same scale of pay. My submission in this regard is, and this is buttressed by what the DGA has said, the audit department has said, is that we do not have the power to create
No,
this post.
Center Council.
Therefore, it is not a palpably wrong order that we have passed. We've even done it in consultation with the DGA.
But the court
So
has directed.
council has the, as per the bylaws as approved by the government of India, and creation of the post and appointment, the council has the power to create and abolish and upgrade the scientific post. If you permit me, I can submit the document, my lord.
Who appears for number 4?
My lord,
Who appears for number 4? Audit department.
my lord, there was a government advocate.
No, now now only two parties, director as well as the finance chairman. So for both, I think.
One Mr. Prakash Shetty had appeared in the
So your party audit made audit department's party. In the facts of the case, the party in person request report.
My lord, may permit me, I can submit some documents, bylaws of the
Party
center.
responded. The audit department, through its competent authority, permission is granted, the cost title will be amended within 1 week. Once the cost title is amended, the registration is issue press notice to the newly added party, returnable on 6th of March.
Lord, may I make just one submission? I am bound by what the authorities in the audit department decide, because they're from the DST and the DGA, which are the administrative
No,
controllers
they-
of my institution. So to hold me in contempt would be incorrect in this case.
There nobody
My lord,
holding,
My lord, they by service
nobody
book,
holding.
my lord, service, I was surprising that audit people not seen the service book, which is not certified, date or time of appointment. I can, if you permit me, I can submit the copy of that service book.
On that day, next day,
Number 38.
the next day.
That's, the direction was to the respondent number 4 and 5 to register the deed of declaration as well as bylaws of the apartment, which has been done, my lords, because I have these copies here too.
Your Lordship, the direction was given on 30th July 2024 with a mandate to complete it within 30 days of time. So we had to approach them repeatedly for the reasons best known to them. They were not ready to register. Not only this deed of declaration, the deed of declaration pertaining to any of the apartment complex, Your Lordship. They were not ready. They were not ready to do the registration.
The reason they.
So again and
the
again, we
reason
have
it
to
was
approach
not,
Your
we
Lordship for the same reason, Your Lordship, for many other associations. It's a
Bylaws, my
statutory
lords.
right, Your Lordship, but we
Bylaws
don't know
has
why
to
they
be-
are denying it, and Your Lordship also has passed an order saying that it has to be done. Very clearly, it is mentioned in many case laws that a deed of declaration has to be registered, and it has to be registered before the jurisdictional sub-registrar. But even after that, for the reasons best known to the bureaucrats, they are not ready, Your Lordship, to register it. Yesterday they did it, that is true, but with continuous follow-up, Your Lordship, and we are losing a lot of time as well as money in this.
My lords, with respect to the bylaws, my lords, it has to be approved by the cooperative society, registrar of societies, and then we have to register. They have not obtained. But anyway, there is a direction, my lords, we have registered.
What you are producing?
That, my lords, they had to, bylaws, my lords, it has to be approved by the cooperative, registrar of cooperative society.
Absolutely wrong, Your Lordship. There is no provision at all. Section 13 and section 11 is very
Bylaws.
clear. Section 13 says that we have to approach to the sub-register office. And section 11 says that after the registration of the deed of declaration,
Now we have
along
complied,
with the
my lords.
bylaw, we can
Now we have
submit it before
complied.
to the cooperative societies registrar. And that is already mentioned in many case laws, Your Lordship. And again, they are troubling the apartment complexes throughout Karnataka. There are multiple of cases. Hundreds of cases only because of this denial. CRP 96/2021, it is very clearly mentioned that who is the authority.
Now we have
And it
complied,
has
my
been
lords.
mentioned in this
there is-
decision also.
There is 100% compliance now, my lords. Have produced the documents that we have complied.
My grievance, your lordship, this is not ending here. Every apartment, the people have to come here before your lordship and beg for this.
To lay down the law, my respectful submission is the remedy is elsewhere. This is contempt jurisdiction and we have complied. The deed of declaration has been registered and the bylaws has been registered.
Your lordship, page number 21 of the order, if your lordship goes through, 20 and 21, the lordship has very clearly mentioned it is a sub-registrar. Then why, how can they compel the cooperative society's registrar to review it and approve it? That comes after the registration before the jurisdictional sub-registrar. Section 13 and section 11, your lordship. They did it, they complied it yesterday after filing this contempt petition. In private properties, they wanted to bring cooperative societies. When we have a specific statute known as Karnataka Apartment Ownership Act. And your lordship, in many cases, 974, 564 last year, your lordship, I have also attached that case law. Your lordship has very clearly mentioned that in residential apartment, it should be under the Karnataka Apartment Ownership Act.
Why you are not registering?
Where is that
Why?
document? Lords, we have registered, my lords. We have produced the document. We have complied, my lords.
Registered.
My lords, I have produced.
Yesterday, they registered it, your lordship, but my submission, your lordship, every apartment, the authorities are denying on the same ground.
Then you file a writ petition.
Yeah, yes, your lordship, I'm just bringing before your lordship that point. The reason we don't know, the reason best known to them, the government officials, especially the cooperative societies, they are refusing it and we ourselves have filed many petitions before your lordship.
Lords, I have placed 100% compliance before this honorable.
Complied it yesterday, that I do agree.
I'm sure that my learned friend would not dispute. There is 100% compliance. We have complied. If there are any other grievance, let them vent it out, my lords. Appropriate.
When there is an order from this honorable court, how much follow-up we have to do and how much money and it's an apartment means a lot of money is lost, your lordship. Maintenance is also not done. It's a statutory right forming an association.
Petition of the petitioner, whereas the complaint hearing came to be allowed by the single judge as per order dated 30th July 24. Disposition 3 and 4 came to be were directed to register the deed of declaration in accordance with the Karnataka Apartment Ownership Act 1972. Exercise was required to be completed within 30 days. Date of receipt of the certified copy. When the contempt petition comes up, it was stated by learned lady standard of it. Found during the Mutation that the deed in question has been registered case of the petitioner. So she produced the relevant documents evidencing the registration. So in that view, the directions are complied with. The contempt does not survive. It's closed off accordingly.
Number 39, Padmanabhar.
I appear for complaint, my lord.
In this, we have filed a writ appeal, my lords. FR number has been obtained.
Writ appeal number?
Lords, FR number, my lords, 44 of 2025.
Order is 23, my lord. The order passed in the year 2023, my lord.
Now they have preferred writ appeal after initiation of contempt proceedings. Direction is at page 28, my lord, para 12. In page 8.
So what is done? No, not done.
That's, we have not complied and we have filed a writ appeal, my lords. FR number is obtained.
Complainant is not there.
My lord, I am appear for complaint, my lord.
While learned advocate for the complainant appears the audio conferencing to press the present proceedings from a learned additional government advocate from the indication stated that the writ appeal FR number
44 of 20.
2425 is already filed. In that view, the file lifts, in that view, while postponing the consideration of the contempt petition. For 3 weeks. Provided that learned additional government advocate shall ensure the list shall pursue with the writ appeal already filed by the state and seek appropriate orders before the competent bench, failing which the respondents will be liable to implement the present order. Send over to 10th March. 10th March is more than sufficient time.
Please.
Number 40 to Chandrasekhar PV.
It's even in this, my lords, the release deed of this, release of the sale deed registered has been released.
Released.
It has been released, my lords, yesterday.
Hmm.
It was a pending registration, my lords, of the sale deed.
The directions of
I am told by party that they given a scanned copy, but original they have not returned.
pardon?
No, they are given a scanned copy attested. They have to hand over the original sale deed. That's what my instructions.
As per my instructions, the council mentioned, whatever deed that is there in the office has been released, my lords. This is a pending registration from 2010-11. So therefore, the whatever documents is there has been released is my
Sale
instruction.
deed is there or not? In that document,
It's there, my lords. This is the,
you received the sale deed, no? That is the only direction, nothing.
Yes,
else.
my lord. They have to hand over the original sale date.
Hmm?
But my instruction that one, today the release, that's what they're telling today. Original they will not hand it over. That's the objection, my friend, my client has told. Because tomorrow, if you go for any sale or for any court proceedings, my lord, they insist for original. Otherwise, if suppose the last, they must say it is last. Otherwise, it deemed that there is no register sale
do
deed,
not
without sale
keep
deed.
the originals, my
Secondary
lords.
evidence, sir.
We do not keep the originals as per my instruction. Whatever document that was kept pending from 10-11, that document has been released.
You file the affidavit that
Yes.
this deed is
Obliged. We'll try.
sent over to. When will file? 16th,
My lords, 2
16th,
weeks.
16th,
Another week's time, my lords.
other week. Send over to 23rd January to be listed at 2:30. For which date learned additional advocate, additional government advocates in the promotion indications shall file affidavit pointing out that as per the direction contained in paragraph 4 of the order of learned single judge, Respondent 3 has released the registered sale deed dated 24/6/11 to the petition complainant. As submitted by send out. Which date? 25th January. 23rd Jan.
This is number 41. The Ranganath Joyce. 41.
Lords, even in this matter, we filed writ appeal.
Writ appeal is filed as stated by learned.
Appeal number 1879 of 2024.
Additional government and the contempt petitions will be listed with the said writ appeal number
1879 of 2024.
1879 of 2024. Next.
Number 42. CH Maltesh.
It's this matter this again is a forest matter, my lords. Lords may kindly grant some time.
Not a forest.
Mutation of entries.
18th February.
Obliged.
Into. So number 43.
No time for the petitioner. The petitioner is a religious institution establishing, Lord has established a temple and a religious community hall. Now the respondent is the adjacent owner. Now, without leaving the setback of 1 meter, he started construction. Original suit was filed. The injunction application was dismissed. Now, in the miscellaneous first appeal, the injunction or interim order was granted, restraining him from putting up the construction. Now, in spite of the order, my lord, he started construction, completed left, right, and center in clear violation of this order, honorable court's order. Now, he is taking shelter under a mistake in the interim order. That I will bring to your lordship's notice at page number 11. Instead of saying that the construction on the eastern side of the appellant's property, the honorable court says eastern side of the scheduled property. But the fact remains is that he is my neighbor and he is putting up the construction on the eastern side of my property, just adjacent to my property. I have a temple and community hall. And the honorable court has clearly said, my lord, on 28 November 2023.
As the learned senior counsel said, my lords, the order of the learned single judge is my lords, not to put up any construction towards eastern side of the suit scheduled property. My lords, the plain schedule at the ink page number 21 is very clear. Their complainant's property on the west side. Property of the Rajput Samaj, that is, my lords, the complainant's property. And the learned single judge has put it on the eastern side. And my lords, this order has been passed on 28/11/23, my lords. Now, they're coming up with saying that there is a mistake, my lords. It has to be rectified by.
Cannot be
the learned
fair
counsel.
because he knows what is my grievance in the civil court. He contested the matter before the civil court. And he knows that my grievance is that he cannot put up the construction without leaving the setback of 1 meter. He put up the construction throughout day and night and completed and put the RCC also. But this may not be correct. A man, my lord, who is aware of the fact, the situation, taking such a plea.
Yes, my lords, I filed. It's filed on
Production of product.
29/8/20.
Compliance affidavit is filed.
My lords, there is no violation at all, my lords.
File it whatever you.
They have filed objections.
Next date, 19th February.